Mr. Goldman, the gentleman from New York, for his 5 minutes questioning.
Thank you very much, Mr. Chairman. I find it really difficult to sit here listening to my colleagues on the other side of the aisle slander personally a cabinet secretary who has committed much of his life to this government and our public service. He was a U.S. attorney. He's worked multiple stints in the Department of Homeland Security. And you're certainly welcome to disagree with how he executes his job. You're welcome to criticize him. You're welcome to make the case to the American people as to why Secretary Mayorkas, in executing President Joe Biden's immigration policy, should be removed from office at the ballot box. But to come in here over and over and over again and to personally attack and slander without any evidence a cabinet secretary who has committed so much of his life to this country, who himself comes from a Cuban family escaping difficult circumstances in his country, who is an immigrant family himself. You should be ashamed of yourself. It's enough. You want to talk policy? Let's talk policy. I agree, we have problems at the border. Let's talk about how we can solve them. But instead of actually going over to the Senate, this committee, which has the committee of jurisdiction over border policy that is being negotiated right now by a bipartisan group in the Senate with Secretary Mayorkas, instead of actually engaging in those substantive negotiations to reach some sort of a bipartisan agreement to address the problems, we are sitting here with a charade of a sham impeachment hearing with expert impeachment witnesses who are Republican officials, political officials suing the Department of Homeland Security. Another hearing. It's the same hearing we've had 10, 12 times. Same pig, different lipstick, because we're now going to call it an impeachment hearing. So who do we have here? And I am sure all three of you are excellent attorneys general. But I have never heard your names mentioned in the category of Mr. Bowman, who is a legal expert on impeachment. And as far as I can tell, none of your states actually are on the border. So I don't understand why we are sitting here in a, quote, impeachment hearing with three attorneys general from different states who are Republican officials and have absolutely no expertise on impeachment. The reason is because the last time the Republicans did that and they brought in their so-called experts on impeachment for the first and only oversight public hearing, they were embarrassed because their own experts acknowledged that there is insufficient evidence to impeach President Biden. So who do we have here? We have attorneys general who are suing Secretary Mayorkas and the government to stop him from implementing his policy to address the issues at the border. That's right. So one rule that the department has implemented was the asylum processing rule, which would allow asylum officers, rather than immigration courts, to decide asylum applications for those placed in expedited removal to significantly expedite the process. That might reduce the backlog. That might create a disincentive to come. That's something that Secretary Mayorkas did to address the border. No, you sued him to stop him from doing that. How about the circumvention rule? Or that is the circumvention, excuse me. How about the asylum circumvention rule, which says that you have to either appear at a port of entry or have first sought asylum from a neighboring country? That would reduce the people who could apply for asylum. No, you sued them. You sued them to stop them from doing that. And how about trying to address the parole decisions to allow some people to come in and be able to actually have work authorizations so that they are not just sitting on the dole? No, you sued them. So this is what we have. We have Republicans suing Secretary Mayorkas to stop him from implementing his policy to address the issues of the border. And now we're going to impeach him because you say he's not addressing the issues at the border. Which do you want? I yield back. I feel like I'm in Alice in Wonderland after that. Every American receives the same application of the law, and it does not matter what your last name is. So I guess that means if your last name is Perry, that subpoenas apply to you as well, lawful subpoenas. Now, I appreciate the gentleman from Pennsylvania's argument that the January 6th committee was not a duly constituted committee, and in fact, he and many others made that same argument to a number of courts of law. The courts are charged with interpreting our laws and whether a committee is a duly constituted committee and whether a subpoena is a duly constituted subpoena. And even though my friend from Pennsylvania may not like the fact that a neutral judge, multiple judges in fact, didn't agree with him, it still remains the law of the land, not what Mr. Perry says, not how I would interpret the January 6th committee, but how every single court of law interpreted it and said it was a validly constituted committee, and every single subpoena issued by that committee was a duly authorized lawful subpoena, no different than the subpoena to Hunter Biden.
Will the gentleman yield for a question?
No, unfortunately, sir, you did not yield to me, so I will not yield to you. The fact of the matter is that subpoenas should apply equally. And for my colleagues to actually claim that we on this side of the aisle are hypocritical because we will not vote to hold someone who has made every effort to comply in every way other than the specific means of providing the evidence is somehow should be held in contempt when 3 members of this committee refuse to comply in any way, shape, or form with a court-determined lawful subpoena is beyond me. Now, I find it interesting that my friend from Pennsylvania also chastises us for just supporting our guy. And I wonder how he would define supporting our guy. Would he define supporting our guy as trying to instigate a coup at the Department of Justice to install a lackey and remove the Attorney General and the Deputy Attorney General so that he could keep his guy in office even though he lost? Is that just supporting our guy? Because that's what Mr. Perry did. The reality is that we are here because, plain and simple, 2 reasons. Retribution for Donald Trump and the fact that the Republicans have no evidence. And you will hear them talk about evidence. You will hear them say, we have so much evidence, we have so much evidence. And we're going to get into some of these details as we go forward. But the reality is that you have been moving the goalposts the entire time because you cannot make any connection, notwithstanding all of your false statements, to the president. So instead, let's subpoena Hunter Biden. Because what we will expect is that he won't testify, or that he'll take the Fifth Amendment because he's under criminal indictment. And then we get to say, aha, all of our specious allegations must be true because if they weren't, he would come here and testify. Well, he called your bluff, and now you're scrambling.
Will the gentleman yield to a question?
No, I will not. And now you're scrambling.
You sure?
Now you are desperate to find anything to divert attention away from your abject lack of evidence connecting President Biden to any business venture of Hunter Biden's, to any wrongdoing. So we're going to hold us here on a contempt hearing because you don't want to see him testify in public. You just want to be able to filter his testimony in closed-door testimony, as you have been doing this entire Congress.
Will the gentleman yield?
I will yield to my ranking member. Thank you.
Thank you. The District Court for the District of Columbia, Judge Kelly, obliterated the argument that
Time's expired. Chair
that the gentleman's
recognizes
about something you made.
Mr. Biggs for 5 minutes.
Thank you, Mr. Chairman. At the risk of taking the bait, which is all this is, it's laying a little bait and might be just too
I
attractive.
appreciate my distinguished colleague from D.C. I want to just take this opportunity to address some of the chairman's evidentiary allegations that you made earlier today. First, I would just note that we keep hearing this over and over and over again, that Donald Trump had a business, Donald Trump had real estate, Donald Trump sold widgets or whatever it is. Obviously, there are many different ways of investing or spending money or getting paid for services, or for simply putting capital into another company. So I don't know what these investments were that Hunter Biden and Devon Archer and these other folks were involved in. Devon Archer testified that it was private equity. That's a legitimate form of business, to invest capital in other companies.
Don't you believe we should get that question under oath?
You got it under oath from Devon Archer, sir. In any event, let's go back to I think the fourth bank memorandum is what you pointed me to earlier today, because you alleged, Mr. Chairman, that there is money that went directly from CEFC, a Chinese company, to Hunter Biden, then to Joe Biden, and $40,000.
Through the shells, yes.
Oh, through the shells, You didn't say that. That you didn't say. So I went back.
Well, you've had a hard time understanding what a shell company is, but anyway, go ahead.
Well, you would know, wouldn't you?
Oh, yeah.
So
That's right.
Here we are, looking at this Fourth Amendment. We have, well, I'll show this chart first because it shows how clear it is. You've got Chinese company going to Biden-China joint venture, going to a Hunter Biden individual entity, going to James and Sarah Biden entity, going to James and Sarah Biden personal bank account, going to Joe Biden. So that, I guess, is what is directly money from China to Joe Biden. It just had to go from a Chinese company to a joint venture that Hunter Biden entered into with another Chinese company.
Would you yield the question?
I just want to finish going through what you told me to go through, and then I'm happy to yield. Then it went to Hunter Biden's personal company that he generally used for a variety of his business ventures. Then it went to another entity for James and Sarah Biden. Then it went to James and Sarah Biden. Then Jim Biden, almost a month later, sent a $40,000 check to his brother, the president, which said was for a loan repayment, and the same bank records where you got this from showed that a loan went from Joe Biden to Jim Biden.
That's not true.
So this is the kind of duplicity that we're talking about. You want to say there's evidence connecting Joe Biden to Hunter Biden's business ventures, and you make a false and inflammatory allegation that money went from China to Hunter to Joe, when in reality, it's 4 pages, it's 21 bullet points of information to get from A to B to C to D to E to F. There's no possible way that you could ever show that Jim Biden knows. This is my time, Mr. Chairman. There is no possible way Jim Biden you could ever prove under any circumstances that Jim Biden knew where that money came from. And you certainly cannot show with any evidence at all that Joe Biden would know that 1 month before, 6 different transactions earlier, somehow this money came from a Chinese investment that Hunter Biden had. You are desperate. You are misrepresenting the facts. There is no evidence. There's no evidence of Joe Biden's involvement in Hunter Biden's business interests. There's no evidence of Joe Biden's involvement in any Mann Act or prostitution stuff. Hunter Biden should be investigated by the Department of Justice, and he has been for 5 years. He is a private citizen. This is what you call an impeachment investigation into the President of the United States based on complete fiction and smoke and mirrors. There isn't a piece of evidence that links anything that Hunter Biden did to Joe Biden, and this is a complete sham.
Your time's expired, and those accounts that they went through were depleted. It wasn't hard to trace the money. When there's not any money in the account,
They don't,
and
he
it
doesn't have the
passes
bank
through-
records.
No, no.
No, but that,
You have the bank records too. You all get every bit
no
of
one
evidence
who
we
receives
have.
the money has the preceding
accounts were
bank
depleted that
accounts
they
records.
laundered through. All right, order,
Chairman.
order. Who's
Mr. Chairman.
Miss Luna's
Can I say
recognized.
something?
Yes, you have
No
5 minutes.
one is above the law. Even if you think that he's innocent, he cannot defy a congressional subpoena. That's what this is about. People here, I'm sure on that side too, have family members that have gone to jail for probably less offenses. So why is he given this special privilege? We have no authority if you have the president's son who's sitting there doing illegal things. I mean, I know it probably doesn't make you feel good to defend the guy, but like, for goodness sakes, he's denied. He should be held accountable. At least bring him in and admit that.
He should be held accountable by the Department of Justice, where he is being held accountable.
Let him. He should be held accountable by the Department of Justice, but that is what we are voting to do, is to send that to investigation, because he denied and defied a congressional subpoena.
Will the general yield?
Wait, let me finish. If the DOJ doesn't uphold that, though, we have a serious problem in this country that this man is held above the law, and that is why we are arguing here today. We are trying to send it to the DOJ, but you're arguing against that. Yes, I yield.
Thank you. Would you agree that members of Congress who outright defy subpoenas should also be held to the same standard?
I believe that certain members are protected under the speech and debate clause. Some people here can probably school me on that, but aside from that, this is a serious investigation. There's been a lot of personal attack in this entire correspondence that we've had in the last, couple hours that we've been here. But what I will say is that Hunter Biden is not above the law. We want to send him to the DOJ, and we want to trust the DOJ to do their job. But right now, the American people have a serious distrust factor with the DOJ, and for good reason. So we would like to pass this, send it to the DOJ, and let's see if they'll do what they promised the American people they would do. I yield my time.
Very good.
Mr. Chair?
Ms. Tlaib?
Yes, thank you
Yes.
so much. I'd like to yield my time to the ranking member.
Ms. Tlaib, thank you very much. I want to pursue the very interesting conversation that we began.
But the reason why folks on this side of the aisle have a hard time digesting that is because your curiosity on what violates the law only applies when it's politically convenient. To talk about Hunter Biden when it's pennies, when it's pennies compared to $2 billion from a foreign government. And I'm not saying that Jared Kushner violated the law, but what I am saying is that was probably negotiated before he left, a $2 billion deal. You announce it months after you leave, probably negotiated before. He never run a hedge fund before. We talk about Hunter Biden having no experience. He never had run a hedge fund before. He was put in charge of Middle East. The $2 billion is from the Middle East. He had no experience in the Middle East. But there's no curiosity because it's Jared and because he's Trump's son-in-law. And so coming to us and pleading with us about Hunter wouldn't sound so hypocritical if there was one of you, just one of you, that would look into the camera and speak into the microphone and say, you know what, that smells pretty bad. We should look into that as well. And I think, quite frankly, the American people would believe you more about your inquiry and about Hunter if they saw your curiosity into the Biden family with the same curiosity into the Trump family. And so that's why we are where we are. It's why the American people have no faith in this institution. And it's also why, quite frankly, many members of your own party have gone in front of the camera and admitted the 118th Congress has done nothing. And so we're here. We would like to do oversight and apply the law and the rules universally. But when we talk about Trump or Jared Kushner, you all look down just to make sure Donald Trump doesn't see you on camera. You can't even look up and be interested that a foreign government, months after someone who actually worked in the White House, Hunter Biden never worked in the White House, months after someone worked in the White House and was in charge of that very region, got $2 billion. Thank you, Mr. Chairman.
Would the gentleman yield?
Sure, yes, I would.
With great respect, your allegations have absolutely nothing to do with what this committee's investigating. And
You're not curious about it, though?
well, it has absolutely nothing to do with anything that we're investigating.
But don't we get to decide? There are questions. Okay, sorry. Go
Well,
ahead.
I don't want to use up the time, but I made my point. I yield back.
Thank you, Mr. Chairman. And I just want to respond to my friend from Florida, gentlelady from California. I think this, unfortunately, does devolve into a partisan exercise. And I just listened with interest at what you say I'm not going to use galls folks on the other side of the aisle and bothers you. And I respect that. So I want to let you know what galls or what troubles us on this side of the aisle based on all the claims that you have made, because many of us, I was one of them, sat in a skiff week after week, day after day. For an impeachment, one of the members of this committee, now, as a staff member then, a staff attorney then, knew there were lies being told to compel the impeachment, to back up the impeachment, to reinforce the impeachment. Lies. Abject, straight-up lies. Not to mention the fact that for years, the other side of the aisle pursued the then duly elected President of the United States based on pure hyperbole about some Russian hoax that has now turned into, it's the same old story from the 1930s in Germany and the 1940s. If you tell a lie enough times, it becomes the truth. We sat and watched you dismantle the country and the presidency and any agenda that the American people have voted for based on that. And to date, to this minute, to this moment, I don't think one of you have ever, to use your phraseology, the kind gentleman from Florida, stood in front of a camera and said, that was pretty bad. Holy smokes, I can't believe we did that. And now, with the benefit of hindsight, we look back, and I look back and I say, how could we have ever done that? How did we ever mislead the American people? How could we have lied? How can we make up for that? How can we recover the lost time? How can we recover the lost reputations? No interest whatsoever. None whatsoever. And again, this isn't about looking back at the past. This markup, this is a markup. This is not a hearing. This markup is strictly and specifically about the actions chosen by Hunter Biden. And I said again, and I'll say it, I said before and I'll say it again, I don't think this committee has any interest in prosecuting or pursuing Hunter Biden. He did this to himself. He made this choice. We all make decisions, and there are consequences to the decisions. He did that. Our duty is to say, is this a breach in the law? Is it a breach? Yes or no? Clearly, he can come to Congress. He sat in this very room today. He was on the grounds the day that he was supposed to appear. So clearly, he can come. He's chosen not to. If we're going to let everybody, look, Secretary Clinton got away with it, right? She was allowed to be deposed, not under oath, in her deposition on a Saturday. No, holiday weekend, she got to do that. That galls the rest of America, who says when the FBI or the local magistrate or some law enforcement agency comes knocking on my door and says, you're going to appear, you've been served. Well, see here, I think I'll set the terms of how and where I'll appear. I'll just do that. Me, citizen X. You know who gets to do that? Apparently Hunter Biden, who thinks he's above the law, who thinks he's special, who he and with the rest of his family, and with all due respect, this administration shows contempt for the law, contempt for the American people, contempt for the Constitution, and contempt for the citizens of this country. Contempt. And that's what this markup is about. And if you want to know what galls us is, you're not interested, you're not the least curious about all of that. With that, Mr. Speaker, I yield the balance.
Mr. Chairman, may I respond, since my friend from Pennsylvania directly addressed me? And I'm happy to have this conversation to compare the 2019 impeachment investigation. Why are you leaving, Mr. Perry? I'm happy to have the conversation, because what you saw in that investigation was 17 fact witnesses who came in and testified under oath, and then 12 of them appeared in a public hearing. There wasn't a single thing that any Democratic member of Congress said that was not supported by neutral Trump administration fact witnesses and what their testimony and their documents said. Contrast that with what we have here. We haven't had a single public hearing with a single fact witness. Not one. The only public hearing we had was a complete debacle where the Republicans' own witnesses said that there is nothing approximating an impeachable offense here. So we're done. We're not having anything out in the public. And you haven't even released the transcripts of all of the depositions. When we had our first impeachment hearing with the constitutional law professors, and I would note, I at least admire your fellow colleagues on the Homeland Security Committee, which I also sit. They didn't even bother to bring in any constitutional law or impeachment experts in their first impeachment hearing today. At least they learned from the debacle that was yours. But at that hearing, we moved to have your own fact witnesses come here and testify in public as part of the impeachment inquiry. And you voted it down. You voted it down. So if you want to compare 2019, that's fine, let's do it. Because every single fact that was in a 300-page report was not spoken by counsel, me, by Adam Schiff, the chairman of the Intelligence Committee, by any member of the Democratic Committee, of the Democratic Party. It was testimony from witnesses who had knowledge, who actually had expertise and experience and factual information about the topic at hand. We don't have that here. And when we have a witness who is willing to come and sit here and give you the evidence that you claim you want to have, you say no. You say no. You understand the accommodation process and how that works in Congress. That means that Congress issues a subpoena, and the receiving party works with Congress to accommodate the interest of both parties so that Congress can get what it needs and the interest of the witness can also be served. Hunter Biden's attorney has done that. He has agreed to every single thing in your subpoena. Every single thing. Under oath, any questions you want, any topic you want, any date you want. He will not raise privileges available to him under the Fifth Amendment. He will answer your questions. The one accommodation he wants is to do it in public in front of the American people, and you are too afraid to let him do that, and I'll yield the remainder of the time to Mr. Raskin.
Now, Chair's going to recognize, Mr. Raskin will have 1 minute and 3 seconds. The Chair's going to recognize Mr. Gosar. I just have to throw in, you must have been absent when the IRS whistleblowers testified with respect to the number of crimes and evidence that the IRS had on the person who we're voting to hold in contempt today. You remember that hearing?
Being
Chair recognized Mr.
prosecuted by the Department
Gosar.
of Justice because
Chair recognized Mr. Gosar.
I will tell you, the gentleman from New York has got some facts wrong. You know, when we were talking to these witnesses, these constitutionals, Jonathan Turley, they said there wasn't, they rose to the occasion of impeachment. But they said there was a suspicion And that's what the impeachment inquiry is all about, to go get that information, if there is. They all said that there was a suspicion based on these shell corporations. So they did say that. They didn't say what you just said. You mischaracterized that. So, you know, from that standpoint, we got to be very, very careful with how we're picking this, cherry picking this information. Maybe we do it, but you do it too. And you did it right there, because they did not have.
Will the gentleman yield for a question?
I'll give you
A quick question. What I said is, and I just want to make sure we're on the same, I said that the witness testified that there was insufficient evidence to impeach Joe Biden.
It was an impeachment inquiry
Inquiry.
hearing.
No.
It was he said there was more than enough evidence to proceed with the impeachment inquiry. That's what we're doing. Let's be
But did
clear
he
about
also
what we're
say
doing
that there
here.
was insufficient
Wait,
evidence?
not
to
Mr.
impeach
Gosar's
him?
time.
No.
He said both. He said both.
You know, and when we're comparing apples to apples on the two impeachments of Mr. Trump, you didn't even go through an impeachment inquiry. You didn't even vote on the floor on one of those. So if you're talking about apples and apples, we're not even close to that. You know, the one thing I thought was you know, the lady justice is blindfolded. She's got the scales. You put the information in there, and she's going to give you a result. She's blindfolded. She doesn't see who that is. You know, Trey Gowdy made that comment. We're missing the point here, is that the information that we got is from factual based. There's information there that is suspicious. Why would you stack all these shell companies up? You got the IRS folks that said this were whistleblowers. They've been exonerated. I got to tell you, they're not liars. They're not liars. They do one thing, they're good at auditing. So I think what we do is we got to get back to the order of business. That is Hunter Biden violated the context of the subpoena. You know, he's not above the rule of law, so we ought to be just continuing that vote. I yield.
Right. Now, Mr. Raskins has a minute and 3 seconds.
First, to my friend, Mr. Gosar, we did not launch an impeachment inquiry for the second impeachment because Donald Trump tried to overthrow the Constitution on January 6th, 2 weeks before he left office, and we were the targets of that impeachable offense. So we all saw it. We were the witnesses, and we were the ones to vote on it, and we didn't quite have time for all of those niceties, but all of us knew exactly what happened. Secondly, I am sorry that Mr. Perry left the room at Josh Hawley's speed when Mr. Goldman began to speak there because he made two really important points. One was he said that if you get a subpoena, you comply with the subpoena, you answer it. Yes, I would like to tell him, Mr. Perry, you comply with your subpoena, but no, he decided to arrogate the law to himself and to claim that the January 6th committee was invalid, it was illegal, it was unconstitutional, all claims that were rejected by federal courts. They do not have a single case authority for that at all, and yet he's going to now lecture other people about complying with subpoena. I mean, he should, I think, delegate some of his time to some other members to speak on that. It's a little uncomfortable there. And finally, I'm sorry?
The gentleman.
Yes, I will yield. Yes, go ahead.
Will allude to good process builds good policy, builds good politics. Would you agree?
Yes, I totally agree.
You don't skip, in the severity of impeachment, you never skip that process. But you did.
Donald Trump was already arguing that he couldn't be tried because it was too late at that point.
Okay.
He was already arguing
All right. Your all's 10 minutes has expired. Mr. Fallon, I think we have a minute and a half.
Thank you, Mr. Chairman. You know, what this has devolved into is deny, 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 counter accuse. It's an old adage, and it's unfortunate because, again, and we've been talking about this now 5, 6, 10 times, the difference between a private deposition is hundreds of hours can be expended, and you can really drill down, and you can have accountability. You can get an in-depth interview, and then at that point, after we've all read that, we can come here and each of us can get our 5 minutes. This is a very big difference, and it's a distinction that needs to be, again, reiterated and refuting some of the Democratic arguments. And then I read this actual amendment, and I see this footnote number 17, this amendment where the author says, Chairman Comer has also dishonestly and repeatedly suggested that the then Vice President Biden had the prosecutor of Ukraine fired as a part of a bribery scheme. Where's the proof? And then you read the footnotes, and there are opinion pieces. The fact is that according to the FBI, the informant, the human source, was very reliable. They paid him over $100,000, and they've been working with him for almost 10 years. Did Victor Shokin, the prosecutor, get fired? Yes. Who was advocating for that? Joe Biden was advocating for that. Mykola Zlochevsky, the corrupt oligarch who was the CEO of Burisma, paid his son millions of dollars. And Victor Shokin, the prosecutor, had seized land, a few homes, and a Rolls Royce from Zlochevsky. So he was apparently doing his job. And even when he was fired, the president of Ukraine, on the call to Joe Biden, said, we thought he was doing a good job, but you wanted him fired, so he's gone. Biden bragged about that. These are all facts. So I'm going to vote against the amendment because the amendment is factually incorrect. And I yield back.
Time has expired for both sides. The question is on the Frost Amendment. All those in favor of the Frost Amendment signify by saying aye.
Aye.
All those opposed signify by saying no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to.
Recorded vote, please.
A recorded vote is ordered as previously announced. Further proceedings on the question will be postponed.
Mr. Chairman.
Does any member wish to be recognized? Ms. Stansbury?
Yes, thank you, Mr. Chairman. I have an amendment at the desk.
I have an amendment at the desk.
For what purpose does Mr. Goldman seek recognition?
My apologies for jumping ahead. I have an amendment at the desk.
The clerk will distribute the amendment to all members. Does everyone have the amendment? No. All right, we're going to let the clerk distribute the amendment. I believe it was changed in the last little bit.
That's okay. I would ask that the clerk read the amendment. No, we're not. My apologies. I withdraw.
While we're waiting for everyone to review the amendment, I'll say we had 3 hours of opening statements. So hopefully we can get through these amendments in time. Just a note, we're working on printing the amendment because we just got it.
You want to move to another one? I can go now if you want to just use the time and I can do mine. I mean, I can do the time and we'll see if it's ready.
Yeah. He gave me the whole stack of amendments, copies for everybody. You have them.
Okay.
So they didn't just give them.
Okay. I mean, do you want to start with another one, Mr. Chairman? Mr. Garcia is ready to go.
We're handing it out now. Proceed with the clerk to read it. Okay. The clerk will designate the amendment.
Amendment to the amendment in the nature of a substitute as offered by Mr. Goldman of New York.
Without objection, the amendment is considered as read. I reserve a point of order. The gentleman from New York is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. This amendment would strike all of the resolve clauses and the report, and it would insert language that details all of the extensive efforts to cooperate that Hunter Biden and his attorney have made in response to this committee's requests for testimony and information from him. That began in February when Chairman Comer wrote to request documents and communications related to our investigation of President Biden's involvement in your financial conduct. The following day, his attorney wrote back to Chairman Comer offering to sit down with the staff to discuss the request. Then, 7 months later, Chairman Comer goes on television and said he never got a response back from Hunter Biden, which is flat out false. And that day, Hunter Biden's attorney wrote again to Chairman Comer to say that he did respond, he never heard a response, but that he remains available to have a discussion. So next, without any response from the chairman, you went straight into a subpoena. The subpoena was for testimony, and the witness, Hunter Biden, has put no conditions or limitations on his testimony. There are no limits on the topics. There's no limits on the length of time. He's happy to do it under oath. He has said he would not assert the Fifth Amendment privilege, even though that's available to him. That's in stark contrast to Devin Archer, their star witness, who so narrowly limited the time and scope of his testimony that we could not ask him anything about any of his own criminal conduct. But the only request that Hunter Biden has made is that he wants to give his testimony in public, not behind a closed-door deposition where his transcript wouldn't be released. There's absolutely no certainty or guarantee that there would ever be a public hearing again, and I would bet a lot of money that you will never put him in that witness chair, whether or not he comes in. That's all he wanted, just to speak to the American people. He has not, unlike your dear leader, filed a lawsuit to prevent third parties from turning over financial information. In fact, you've received tens of thousands of bank records. The problem you have is not Hunter Biden's cooperation. It's that all of those bank records, which would show any connection between Hunter Biden and his father, if there were any, has zero money going from Hunter Biden to Joe Biden related to any of his business ventures. So your problem is that the evidence doesn't show what you say it does. It's not that he's not cooperating, so that's why we're here today, so that you can change the topic, can claim that there's some kind of obstruction, and therefore Hunter Biden really did do all of these terrible things, and Hunter Biden should be impeached. Oh, wait, no. It's not Hunter Biden who's being impeached here. Now, this is far worse because the chairman, as we've discussed many times, has multiple times offered Hunter Biden to come testify in public. So if you had wanted a closed-door deposition, I don't understand why you would go on TV, Mr. Chairman, and offer for Hunter Biden to come in and testify publicly, whichever he chooses. So why no public hearing? Why won't you have a public hearing? The only request, this is an incredibly cooperative witness. We've all dealt with many witnesses who put a lot of restrictions on their testimony. There's one request of Hunter Biden, which is to speak directly to the American people, not in a closed door to the Republicans who will control the release, the dissemination, and the misinformation from that testimony. Why not? Well, one of your own colleagues went on the House floor last fall and said that this impeachment investigation was, quote, failure theater, unquote. A Republican said that. So the theory here must be, let's avoid the theater part of that and just keep the failure behind closed doors. Last month, Hunter Biden showed up to the Capitol on the day that he was subpoenaed, ready to testify in this hearing room. You refused to take his testimony. That very same afternoon, You went on the House floor to vote for an impeachment resolution on the rationale that you needed to pass a resolution to get more evidence. You reject evidence in the morning, and then you cry foul about no evidence in the afternoon. He's ready to testify, and this is a dangerous precedent you're setting if every single line in every single subpoena must be adhered to, or you're going to hold in contempt. I know my colleagues on the other side of the aisle who defied subpoenas outright would be very afraid if that becomes the standard here. And I yield back.
And I'll recognize myself. I oppose this amendment. This amendment claims that Hunter Biden has cooperated.
Because it goes to the heart of the dispute that the chairman and the witness seem to be having, which is where would his testimony take place? The chairman is insisting that it be done in a closed-door deposition, whereas the witness is insisting to take up the chairman's original offer to do this in a public hearing. And one of the reasons that the witness continues to push for a public hearing is the Devon Archer closed-door transcribed interview. That is one of only 2 transcripts of, I believe, at least 18 transcribed interviews or depositions that this Republican majority has released. But it gives us really, really good insight into exactly what the chairman and the majority would plan to do with Hunter Biden's closed-door testimony. Let's take, for example, just, I think, earlier this weekend, Chairman Jordan of the Judiciary Committee, also a member of this committee, said on television that the most powerful evidence of President Biden's wrongdoing is the testimony of Devon Archer. So I wonder what is that testimony that is so powerful? Was it the testimony of Devon Archer when he said that President Biden was never involved in any of Hunter's business ventures? Or was it the testimony that President Biden never received any money from Hunter's business interest? And remember, Devon Archer testified he was Hunter Biden's primary business partner. He was on the board of Burisma with Hunter Biden. So he had firsthand knowledge of all of Hunter Biden's business deals. Now, maybe if it wasn't those, it was the fact that President Biden, according to Devon Archer, never received any bribes from the Ukrainian government. In fact, maybe it was even that he said that President Biden never discussed business with Hunter Biden or Hunter's business associates. It must be that he was focusing on the times when President Biden met or spoke to Hunter Biden's business associates. That clearly has to be what the chairman was talking about. So it must be that when you look at the transcript, what he was referring to is when Devon Archer repeatedly said that they never discussed business, that they only talked about, quote, niceties, including, and this is according to Devon Archer's testimony, how the weather was, and that none of the discussions ever related to business. So the best evidence that these Republicans want to put forward is testimony that completely absolves President Biden from any involvement, association, benefit from, or other interactions with Hunter Biden's business interests. Now, Chairman Comer, you were asked a few weeks ago on CNN what you thought the best evidence was of wrongdoing by President Biden, and you said that the allegations of the bribe from the Burisma founder, should we call it, I guess, the Burisma hoax now? Because unlike with Russia's interference in the 2016 election, which Special Counsel Mueller unequivocally determined was known to the Trump campaign, was welcomed by the Trump campaign, and was used by the Trump campaign, in this case, Vice President Biden's urging Ukraine to fire the Prosecutor General of Ukraine, which was consistent with official U.S. policy. It was consistent with the European Union policy. It was consistent with a bipartisan Senate delegation, who urged it as well, was actually bad for Burisma, and therefore it was bad for Hunter Biden. And who should we look to determine whether that is the case? How about Devin Archer, the star witness, who was also on the board of Burisma? Nope. Devin Archer said that it was his understanding that Burisma had Shokin, the prosecutor general, under control, and that getting rid of him would have been bad for Burisma. And of course, it was bad for Burisma, because as soon as Shokin was gone, after he had allowed a British case to lapse, the next prosecutor general came in and did start investigating the founder of Burisma. So it turned out to be exactly correct. This is why Hunter Biden wants to testify in public, is because if you had not released that transcript and we had just relied on the false representations of the majority members of this committee about what Devin Archer said, we would never have known that Devin Archer actually absolves Joe Biden of any involvement of any wrongdoing related to Hunter Biden's business interests. And we would not know that this entire investigation, the public would not know that this entire investigation is a complete sham. And I yield back.
The minority will have 4 minutes. The majority has 10 minutes. I'll go first. I must oppose this amendment, but I have to state something. And I want everyone to understand this. A lot has been said about people on this committee running to the press during a deposition or during an interview. During the two main interviews of this impeachment inquiry investigation, the Devin Archer interview and the George Burgess interview, the very first person on this committee to run to the reporters was none other than Dan Goldman. That is a fact. Does anyone want to dispute that right now? The very
I would like you to identify one thing that I said that was not consistent with the transcript.
You're talking about you are talking about running to the press and leaking.
Release the Burgess transcript.
You said Hunter Biden didn't want to come because of leaks. You're the leaker. You are the leaker, Mr. Goldman.
You do your check.
You have 4 minutes remaining. This is my time. You're out of order. You're out of order. I let you sit there and regurgitate your baloney for 6 minutes. I oppose this amendment. This amendment strikes the entire section about why Hunter Biden's testimony is necessary for the committee's legitimate oversight investigation. The amendment discusses a single deposition with Devin Archer and gets rid of all other relevant information as to why his deposition is important. The amendment distorts the reality of how the committee has handled this investigation. Devin Archer has stated publicly that claims made by the Democrats in this amendment are categorically false. Specifically, Devin Archer stated that Democrats' claims that President Biden was not involved in Hunter's businesses in any way was false. Devin Archer said that's categorically false. He said Joe Biden, quote, was aware of Hunter's business. He met with Hunter's business partners. I recommend that all members of this committee oppose this misguided amendment, and I ask to submit to the record Devin Archer's interview where he says one Democratic claim about the Biden business is categorically false, and that was what I just mentioned with respect to Joe's involvement, knowledge in his businesses. Without objection, so ordered. Now the minority party has 4 minutes remaining. Chair recognizes Ms. Stansbury.
Thank you, Mr. Chairman. I just very quickly want to clarify that when I mentioned that the majority had run to the press and misrepresented what happened in that interview yesterday, the point was that they misrepresented what happened in the interview. And I know that for a fact because somebody shared with me the text message that the Republican staff sent around all the members, and I also heard directly from the press what was said. So that's what we're talking about here is misrepresentation of the facts. And with that, I yield to the ranking member.
Thank you very much. And but I'm fascinated by this exchange because most committees I've been on, when the transcripts are released, it serves the vital function of transparency, but it also keeps people from misrepresenting and distorting the facts in advance. But if you withhold all but 2 transcribed interviews, I think there's something like 16 or 17 that haven't been released by the majority, then that does become an incentive to misrepresent and distort. I don't blame Mr. Goldman if he ran to the press to try to get out the true story before others go out and tell a lie about what's taking place if we're not going to turn the transcripts over. And I wonder whether you, Mr. Chairman, could commit to turn over all of the transcribed interviews
The
to
gentleman
everybody on
yield
the
for
committee
question.
and to the Congress and to the people of the
The
United States
ranking
of America.
member
Yes,
yield
by all
for
means.
a question?
Yeah.
Does the ranking member presume that his Republican colleagues intend to lie about transcripts?
But
You seem to have that presumption.
What I will presume is based on the facts that there have been multiple distortions and misrepresentations in the past, and the vast majority of the transcribed interviews have not been released. Someone give me the exact numbers, but I believe only 2 transcribed interviews out of 17 or 18 have been released. I've never seen that before, and I'm baffled by it. I don't understand it.
In the ranking member's esteemed background and knowledge of judicial affairs, when there's ongoing investigations and multiple witnesses in complex cases, isn't it common for full transcripts to not be released?
No, it's not.
Within the parameters?
No, but I don't think so. But in any event, we're talking about some that took place 6 months ago, 8 months ago. But somebody's going to give me a list of how many we're talking about here. There's 17 total. Only 2 transcribed interviews have been released. So then it does become a race to get out to say, you know, what you think happened. Why don't we just give the people the transcribed interviews? We talk about transparency and accountability. That's the dominant theme of this committee. Isn't that something we can agree to?
Will the ranking member yield for 1 minute?
Yes, by all means.
I yield.
I have a question for the ranking member. If it is generally the practice of an investigator to withhold all of the transcripts during the investigative phase, would that normally also include releasing 2 of them?
Well, that strikes me as odd. That does look like, the famed cherry picking. It's as if to say, well, 2 of these interviews helped us. 15 or 16 of them don't help us, so we're going to bury them someplace. So that's odd, but I want to presume the best of my colleagues, Mr. Higgins, and that's why I'm asking the chairman to explain what is the practice here.
Well, you complain that we don't release transcripts. You complain because we do release transcripts. Honestly, we released those 2 transcripts because you had misrepresented so much what Devin Archer said. That's probably one reason he went on Tucker Carlson's show to call you out for misrepresenting what he said in the transcribed interview. But
so you are able to get them ready. You are able to get them ready, in other words, and you thought that it was
strategically we have other witnesses
important.
to interview. You know how it works, Mr. Askins. You're playing like you don't know how this works. You're playing and trying to act like you've never done an investigation before when you've led both impeachments and the January 6th.
I didn't lead the first impeachment, but
I wouldn't want to admit to leading that first impeachment either.
I would have 10 nicknames from President Trump by now if I'd led that one.
Well, you got, I think your all's time is pretty much expired. Does anyone on our side have anything to add? I don't see anything. So, who's that? Mr. Gosar.
Yeah, we talk about facts. It wasn't U.S. policy to do what Biden did in Ukraine. The Obama administration actually said that Ukraine had complied with the law and that the loan should go through. Yes, they did. And that the vice president changed it on an audible over there. So the other thing I want to point out is if the president didn't know anything about Hunter Biden's businesses, how do you explain the 14, 15, 16, I can't remember now, how many times his partner actually went to the White House? How do you explain that? How do you explain this guy, Devin Archer, shows up at the White House? Who are you? Normally, the person's going to say, well, I'm Hunter Biden's business partner. That's typically what the average person would say. So how come you didn't know anything about that?
Mr. Gosar, for the 6 people in America who are still watching our hearing, could you just explicate what you think the presidential crime is?
Oh, I'm just saying right now, we're just talking about the facts. The facts here are misplayed. I mean, you complain about us, I'm going to complain about you
Would
because
the
you're
gentleman
distorting
yield
the facts.
for 1 second?
I'll give you a second.
Mr. Gosar's time.
Just, I'm not going to ask you to take my representation for it. I would ask you to go read the transcripts of the State Department witnesses in the first impeachment who were in the Ukraine embassy and in the State Department and were the ones who created and made the official U.S. policy, who all testified that Vice President Biden was acting consistent with official U.S. policy.
Okay, well, that's not what we received. And when you start looking at this, you know, the courts, you know, I know the ranking member always goes to the courts. You know, you had a judge that basically said this honeypot of a deal for Hunter was no good. No one was going to get that. How do you explain the slow walking, you know, by the Justice Department on the IRS claims? And how many people get a chance to do that?
Well, with the gentleman yield, that's a great point. And when the courts ruled against Hunter Biden, I don't think you heard a single complaint from anybody on our side of the aisle. We said, let the justice system proceed. But when the court said that the January 6th committee was validly and constitutionally composed, we still have people today who violated their subpoenas who are whining about how the committee is illegal. I mean, come on. I mean, how do you feel about that one?
Could I ask you a question about that?
Yes.
Just out of curiosity, why did you all not hold them in contempt?
Hold who in contempt?
The people that didn't.
Oh, we didn't have time at that point. I mean, we got up to the very end of the Congress.
I was just wondering.
But if you want to work on it now, let's do it.
No.
I'm totally with you, Mr. Chairman.
No. I was just curious as to why you didn't. All right.
Well, let's make it bipartisan.
I'd like
Everybody
to
good?
that
We're
we
square?
hold anyone who's violated
No, I was just wondering. I mean, that's a tool that Congress has. If someone, you've been on TV several times saying that people should honor congressional subpoenas.
And I
when
believe
they don't, you hold them in contempt.
Whether it's Steve Bannon, Dan Scavino, Jim Jordan, or Hunter Biden, if somebody is...
But you did hold the other two.
I'm sorry?
You did hold two of those in contempt of Congress.
We did. Well, Steve Bannon's been convicted by a jury, by a court. He's been convicted in court. And still, I don't think we could get a single person on your side of the aisle, other than Ms. Mace, to utter a word about people who violated subpoenas in the last Congress. I mean, that's extraordinary. And all that I've been saying about Hunter Biden is he accepted what was your original offer. You didn't like that offer anymore. You put out.
Let me say this, and then your time's expired, and we're going to get to the vote. Hunter Biden is more than welcome to come for a hearing after the deposition.
Okay, you didn't say that before, but that's cool. You've changed the offer.
Chairman, hold on. Will you
No,
guarantee
the time is
that
expired,
there will
Mr.
be a
Goldman.
public
You have
hearing?
talked and talked.
Will you
and
guarantee
talked.
that there will be a public hearing if he were to come in?
After the deposition, I
You
guarantee.
say right now
yes.
we'll have a public hearing
Yes.
with Hunter Biden.
Absolutely, we've said that. All right.
Yeah, I know. We heard a lot about public hearings that have
Very
not
good.
happened.
The question on the amendment.
Mr. Perry.
Thanks, Mr. Chairman and gentlemen. God bless you for your service. I really, really appreciate your sacrifices on behalf of this nation. As often is the case, my position here up on this dais is my 5 minutes. Most of it will be spent correcting, in my opinion, the record of the things that have been said previous, as opposed to the questions I might have asked each of you. So I'm going to go through a couple things here. And maybe it's not only correction, but it's clarification of the record, as I would like to say it. Sure, Mr. Seidel, is that how you say your name? Sidgley. Sorry about that. My apologies.
My mother got it wrong for years.
I'm sure. The name tag was probably difficult. I just want to make the remark and the point that the segregationists that blocked integration were decidedly in one political party. And I think it's important to note that because they will be up here acting like they never did that. And it's important for the historical record as a fan of history that that you can appreciate that there are consequences that America cannot forget and should not forget. Regarding diversity, I hear that all the time, diversity is our strength. Diversity is our strength. And it's, Mr. Thibault, you just answered a bunch of questions about that. And it is a strength when we have different viewpoints about how to solve a problem. But if we're all in a rowboat, there's 4 of us in a rowboat, and we all have a different idea of where we're going in a different oar, diversity is not going to be much of a strength, right? We're all going to be rowing in 4 different directions. So diversity is a strength, and we're all pointing in the same direction. Otherwise, it's not a strength. And I don't know how that can be refuted, but if somebody wants to, they're welcome to do that. Regarding the comment that there was a defeat in Vietnam, I want to make sure, because I grew up during that time, as you did, I imagine, sir, just gauging from seeing you here, it was not a military defeat. It was people like Walter Cronkite and other leftists and political activists in the United States of America that imposed that defeat, and it's important to me. I revered my uncle when he came home from Vietnam in his uniform as a guy who served and the sacrifices he made, and it colored my decision to join the military. And it's important, again, for the record, to remind Americans that the military did not lose that war. That was a politically lost war, and I don't want that to be attributed or ascribed to the military. Regarding the McCarthy hearings, I want to remind everybody in the room that while I disagreed with his tactics, as most Americans did, if they read Whittaker Chambers' book Witness, and if they go through the Venona transcripts, almost every single person he named was a communist sympathizer, organizer, and involved in the subversion of the United States government. Let's not forget that. Regarding those folks that were held up by by Senator Tuberville, and the fact that they didn't complain, well, good for them. Because when we wear the uniform, yours is not to question why, yours is just to do and die. And we don't talk about political things because it is against the regulation. So they weren't doing anything grandiose. They were doing their duty as they should. And Tuberville was doing his duty as he should. The policies in the military regarding the subject at hand are wrong. And thank God somebody was willing to fight for them. There is a specific definition for merit. I would ask my colleague, he can go look up any search engine and see it. I joined the military, and I love my time in the military. It defined me, and I defined it. And it was based on merit. And I didn't have a leg up. I knew my uncle who served in Vietnam, but when I raised my hand as an E1, no one knew anybody I knew, and it didn't matter. And I love the fact that even coming from a broken home with no connections and no clue about anything, I could work my tail off and make something of myself. And even though I didn't have my commander's recommendation to go to officer candidate school, I got into officer candidate school, and I became the president of my class. And even though I didn't have a recommendation to go to flight school where you're measured within 1/10 of a point, I graduated second in my class alongside soldiers and service members from the Air Force Academy and West Point, of which I was not allowed to go to because I wasn't good enough. And I wasn't good enough. But the point is I worked my tail off because it was based on merit and I could make something of myself. And while I complained to myself, I didn't complain to anybody else when I tried to get an inter-service transfer from the Army to the Air Force, because instead of flying Cobras, I wanted to fly F-16s, and a friend of mine, he got to go. He was a black man. But when I applied to the same unit, I was told, sorry, you don't fit the position. You know what I did? I got after my job as a Cobra pilot. I got after my job and I went on with my life. I didn't cry my eyes about it. There's a bunch of people that are up on this dais today that are going to complain to you and tell you about your life in the military who have never served and don't have a damn clue about any of this. But Mr. Lohmeyer in particular, Mr. Thibault in particular, God bless you for your viewpoints and your willingness to sacrifice what you have for the things that you believe in, because you are correct. Our military is being destroyed right now, and we all know it. We all know it. And while I wish and I hope that it still remains the best military in the world, I'm not sure that that's the case anymore, and we better damn well come to that realization and get after that. Mr. Chairman, I yield.
Thank you, Mr. Ivey. I have some familiarity with impeachment, and I can tell you that this impeachment is an absolute abomination. If the impeachment clause could talk, it would beg for the Republicans to stop shaming its name. There is no treason, there is no bribery, there is no high crime and misdemeanor. You have two completely made-up accusations in a litany of articles of impeachment that simply recite policy disputes because the Republicans do not like how President Biden and Secretary Mayorkas have tried to address the issues at the border. And do you know how much they haven't liked it? There are 3 significant policy changes that this administration has implemented to streamline the asylum process, reduce the backlog, stop people coming over the border in between ports of entry. And all 3 of those policies were sued in court by Republican attorneys general. So the Republicans are literally trying to stop the administration from securing the border while they are saying, and so that they can say, that the administration is not securing the border. They are creating this situation, and then they want to blame President Biden. So then we get to the supplemental, and the president offers $14 billion, requests $14 billion to do exactly as what Mr. Correa said, what my colleague, Mr. Thompson, said, which is to provide more resources to the border, to provide more technology, to provide more asylum officers and immigration judges, to reduce the backlog of immigration, to provide $1.4 billion to the Shelter and Services Program, to reimburse cities like mine, New York, which have received more than 100,000 migrants over the last year. That is the only program that is authorized to reimburse cities and localities for money they spend on migration, the Shelter and Services Program. $1.4 billion. Do you know what how much the Republicans have proposed to give to that program? Notwithstanding everything you hear from House Republicans in New York claiming that the federal government, the Biden administration, is not doing enough to help New York City, zero. They zeroed out the program. And so this is where we are right now. Secretary Mayorkas, for the last 2+ months, has been working overtime, negotiating with a bipartisan group of senators to pass legislation which is required because the administration does not have the authority it needs to do everything to secure the border. We need legislation. And Secretary Mayorkas has been working with Republicans and Democrats in the Senate to come forward with a border policy solution. We're now nearing the end of it, reportedly. No one has seen the bill text. But what is very clear is that Secretary Mayorkas and President Biden have agreed to concessions that Republicans have never gotten before and will never get again, because the administration wants to actually solve the problems at the border. So you'd think the Republicans would jump at the best deal that they've ever gotten. No. No. Donald Trump, Speaker Mike Johnson, are trying to submarine and sabotage this bill, saying it is dead on arrival in the House before they've read the text of it. Why? Because Donald Trump wants to run on the crisis at the border. That is all. They want to use the border as a political cudgel. They do not want to solve the problems at the border. And you don't have to take my word for it. You can just listen to Donald Trump himself, who has repeatedly said it. And so what the House Republicans are doing at the direction of Donald Trump, instead of going over to the Senate and working on those negotiations to pass bipartisan legislation, no. They are impeaching the secretary for failing to secure the border while he is negotiating legislation to secure the border. If that is not irony, I don't know what is. This is a political stunt. It is a sham impeachment designed to give Donald Trump a talking point. The Republicans do not want to solve problems. They want to create chaos because, as Leader Jeffries says, they consistently put politics over people. And we are here to tell everyone in America that we want to address the solutions at the border because we want to secure our homeland and we want to do the work that the American people sent us here to do. Thank you.
Thank you, Mr. Ranking Member. Can you just, and maybe for the fellow attorneys on the, or other attorneys on the group, can you just explain a little bit your argument against the Republican argument that a willful disregard or neglect of the law on behalf of Secretary Mayorkas, you know, they say that is impeachable, and why you say that that does not rise, and then their second article being, you know, his truthfulness to the committee. And I just also had a second question, if I could throw it out there, maybe for the leader, about the president's comments over the weekend that he would shut down the border. I'd like to know what Democrats are thinking about that as well. Thank you.
I'll take the first question. If you could prove that Secretary Mayorkas was knowingly, willfully, and intentionally allowing fentanyl into this country, violating the laws in order to allow people to stream over the southern border, you might get to whatever this notion of willful neglect is that they've come up with. But even then, that has never been used and never been determined as a high crime and misdemeanor. So, of course, you can't prove that. He's taken innumerable actions. He has come to the Congress asking for more resources to stop the 500,000 American-made guns from going from the United States over the southern border into the drug cartel's hands so that they can control human trafficking and fentanyl at the border. There is a bill I introduced to address that. The Republicans will not co-sponsor it, much less address it. He has taken numerous actions. The Republicans just don't like what he has done. But elections have consequences. Too bad. And if the Republicans are gonna open the door to impeach a secretary because they don't like how that secretary is doing his job, well, what happens if there's another child separation policy? What happens if another president pulls out of the Paris Climate Agreement over the will of Congress? There are a slippery slope of any number of different disagreements that would then rise to the level of impeachment. And the reason why you don't see any support, and you're asking me what the argument is for it, is because they have not shown you any support for the notion that this is a high crime or misdemeanor. I've not seen any legal analysis. I've not seen any historical precedent. Nothing. Nothing. It's not going through the Judiciary Committee because that committee requires due process for impeachment. There's been no due process here. This is a rushed, sham impeachment that is purely being done for political purposes, but it will have a really, really detrimental impact on this institution.
Just to follow up on that, and not to get too much in the weeds, but you asked for it, basically. If you go through the articles of impeachment, it actually quotes a case, United States v. Texas, and Alito's dissent in that case. If you look at the majority of, well, first of all, it's a bad idea to have to quote the dissent, especially in an 8-1 decision, where all of the Trump appointees are on the other side of it. And one of the Trump appointees, Justice Kavanaugh, wrote that prosecutorial discretion, which is the actual term for this, it's not willful neglect of the law, it's based on the fact that prosecutors can't prosecute every case, every time, and that the Constitution gives the executive very broad discretion to make those decisions. And it's especially true in the immigration area. And as Justice Kavanaugh pointed out, it's especially true in this particular issue because the last 5 presidents over the past 27 years have had to make the same kind of decisions. Some you prosecute, some you don't. Ironically, this group, the House Republicans, have tried to take the articles of impeachment and invert that around and say what this prosecutorial discretion is impeachable, which is outrageous because prosecutorial discretion, not just in this instance, but for prosecutors across the country, they use that all the time. And the Supreme Court's been saying for more than 6 decades and beyond, that's protected. So and that's their lead argument, by the way. That's their best argument as to why you should be impeached. It's totally rejected 8-1 by the Supreme Court, by the history of the Constitution, and by all of the witnesses that testified.
And might I add, some of our members on the Republican side over the last week have said we should ignore the rulings of the Supreme Court. So that's just how far we've come in this country, that when our Supreme Court makes a ruling, sometimes you agree, sometimes you don't. But I know of very few people who would say, ignore the court and just do what you want to. And so that's where we are in this debate.
5 minutes.
We're here based on 2 completely fabricated, unsupported, and never used before articles of impeachment. This is completely debasing and demeaning the impeachment clause of the United States Constitution, and it is a gross, gross injustice to the credibility of this institution. In your opening statement, Mr. Chairman, you quoted James Madison as saying that the impeachment clause is designed to remove bad men in office. But notably, the impeachment clause is not designed to remove bad policy from the office. And the definition of bad men, as Professor Pearlstein said, is an individual who abuses his power for personal gain. It has there's never been an impeachment in the history of the United States where someone has been impeached for something other than the abuse of power for purposes outside of his official duties. That is for elections, and that is for legislation. This, on the other hand, is an impeachment process that you are moving forward because you claim that Secretary Mayorkas, who's obviously working under the direction of President Biden, is failing to secure the border. The irony of the fact that Secretary Mayorkas has spent the last 2 months plus with a bipartisan group of senators negotiating legislation that would address the problems at the border should not be lost on anyone. You are sitting here right now trying to impeach a Secretary of Homeland Security for neglecting his duties literally while he is trying to perform his duties and negotiate legislation. Now, the real reason we are here, as we all know, is because Donald Trump wants to run on immigration as his #1 issue in the November 2024 election. And you don't have to take my word for it, because he said it himself. And last week, numerous Republicans echoed his call. Why would we actually solve the problems at the border when it is such a good political message to use for the election? And Leader McConnell even reiterated in a closed-door meeting of the Republican members of the Senate that we're in a quandary, he said, because our candidate wants to run on immigration. And we don't want to get in the way of our candidate. Now, I know this weekend I saw Chairman McCall on TV and others, and you're changing your tune now because you said the quiet part out loud that this is all about politics. And so now it's, oh no, the president can do it without legislation. Never mind that you've been calling for H.R. 2 this entire Congress. No, now it's he can do it himself. Well, he's tried to do it himself. He's tried. He's passed numerous policies that would have streamlined the asylum process through ports of entry where migrants are vetted, that would have presumptively made ineligible anyone trying to cross the border in between ports of entry, and would have done a number of different things to address the problems. Republicans went to court to sue him, to stop him from implementing the policies to address the border. So your own party is sabotaging and undermining this administration's efforts to address the border while you are trying to impeach him by saying that they're not addressing the border. The hypocrisy is the least of it. Your attack on the rule of law and our democracy is the worst of it. And you better be careful about the bed that you make. I yield back.
The gentleman yields, and I appreciate the gentleman.
Gentleman from New York is recognized.
Thank you, Mr. Chairman. Mr. Bishop, I'm happy to write you a poem, if you like.
I can't wait.
But, you know, I want to go back to something you say, which is some memo or whatever, that all we want to do is talk about Donald Trump. The fact of the matter is that this committee, which may go down as one of the most useless and worthless subcommittees ever created by Congress, is called the weaponization of the federal government. And the reason we all know now that this was created and stood up is that the Republicans are trying to flip the script and to distract from the fact that the true weaponization of the federal government with evidence and facts and support was done by Donald Trump and his administration and will be done by Donald Trump and any future administration. Now, this also goes back to 2016 and the fact that Special Counsel Robert Mueller, the unanimous opinion of the intelligence community, pretty much everyone who looked at this concluded that Russia used false information on social media to interfere in our 2016 election. And the problem the Republicans want to rebut and undermine and distract from is that they did so to help Republican candidate. And so if you attack the Democrats as the real weaponizers of the federal government, then you get to flip the script and turn it on the Democrats and say, oh no, they are, and get to continue doing and opening up the avenues for additional real weaponization of the federal government. Now, Mr. Lukianoff, do you think there is a First Amendment right to distribute deepfakes online?
Is there a First Amendment right to distribute deepfakes online? Of course there is.
Okay. Now, do you think that there's a First Amendment right to distribute deepfakes online with the intent to interfere in an election?
If you add additional steps to it, it can potentially be criminal. Sure, but to create them and distribute them.
I'm not even going to waste our time getting into this because what you have just highlighted and agreed to is that this is a very difficult issue. The balance between the First Amendment and what is free speech and what is
respectively, Congressman, you don't seem
I'm
to
not
be taking it seriously at all.
Sir, I didn't ask a question.
You said this was a useless hearing.
I didn't ask you a question, Mr. Chairman. I'd like to reclaim my time.
The gentleman has the time.
That the problem that we are facing in the post-2016 world where social media is used as a weapon to interfere in elections from foreign governments is that this is a difficult thing to navigate, that balancing the First Amendment, which all Democrats support, but the First Amendment is not absolute. There's obviously some speech that is not protected, and balancing the interests of free and fair elections is a complicated situation. What is not complicated is, and by the way, this has been the theme of this committee for the whole year. I believe the committee has interviewed more than 30 witnesses, and every single witness behind closed doors has said that the government has never coerced, pressured, or threatened any social media company into taking any action. The whole premise of this theory falls apart. What we should be focusing on is Chairman Jordan abusing the power of his committee in the Congress to subpoena state prosecutors in an effort to undermine their prosecutions of his revered friend Donald Trump. That is no place for Congress to be, no place for the committee to be. That is a true weaponization of the federal government. And when we start talking about other things that are the real weaponization of the federal government, such as Donald Trump's statements that he will just indict his political enemies, or that he would use the Insurrection Act to deploy the military against civil protesters, or even that he had argued his lawyers, one of whom has appeared twice here as one of our favorite witnesses, John Sauer, actually said that if Donald Trump ordered SEAL Team 6 to assassinate a political rival, it could not be a crime unless he was impeached. Somehow that is a predicate. The fact of the matter is the true weaponization, the threat of weaponization is from Donald Trump and the Republicans, and we ought to move on from this charade. I yield back.
Gentleman yields back. Gentleman from Florida.
Thank you, Mr. Chairman. Just to follow on with my colleague from North Dakota, the notion that subpoenas are not sufficient to get information and that every ounce of evidence must be obtained by a search warrant has, of course, been repeatedly rejected by the Supreme Court over and over and over. And this hearing, the reason why, as Mr. Armstrong says, we are talking about January 6th is because, as I understand it, this hearing was initially spurred on by an FBI whistleblower who is not here testifying today. The one who ostensibly had the information about alleged wrongdoing is not here to stand in front of us, to testify under oath, to be questioned by members of both sides. Mr. Knight, I want to ask you a hypothetical. Let's say that there's a riot and an attack on our democracy on a particular day. We'll just call it January 6th for the purpose of this hypothetical. Let's say that the FBI has information that an individual was near the site of the riot that day. And let's say that the FBI had evidence that that individual purchased a firearm in the past 6 months. And let's say that the FBI had evidence that that same person planned to return 2 weeks later to interfere with another democratic process involving the President of the United States. Is it actually your testimony here today to say that it is a violation of the Fourth Amendment for the FBI to seek bank records for that individual?
May I ask a clarifying question?
Sure.
So, at least based upon the public information I have available, they did not know on an individualized basis that people were planning to return to cause violence. And I think that's a distinction that's worth noting.
That's fine. I agree with you. That's not in the hypothetical. They just knew they were going to return.
I believe you said something along the lines of evidence that they were coming back
to interfere. You're right. Let's just say that. Do you think the Fourth Amendment prohibits the FBI from getting bank records for that individual if they don't know that they are going to commit violence?
I think that's an easy warrant to get.
A warrant?
Yeah, I think that would be an easy warrant to get from a judge.
So you're now saying that you need to get a warrant for bank records?
I am saying you should have to get a warrant for bank records. The status quo is you do not.
You disagree with the Supreme Court, which has upheld the constitutionality of the Bank Secrecy Act.
So if you'd like to talk about the Supreme Court precedent in the Bank Secrecy Act, I think that Carpenter, which is a far more recent case, points to some very strong questions about the constitutionality of the Bank Secrecy Act. I've written something about it. I'm happy to send to your office.
I understand. And by the way, I agree. I mean, but Carpenter also demonstrates that the Supreme Court is evolving and is evolving on the Fourth Amendment, and there's no question, and I will tell you as a former prosecutor, if I had that predication, I would fire off a subpoena to that bank every single day, 10 out of 10 times.
Well, respectfully, sir, it doesn't seem like they even use subpoenas here.
I have to move on. I have to move on because I think it's absolutely absurd that we are sitting here trying to make an argument that somehow the Fourth Amendment is being violated when there is specific, reasonable suspicion about every individual whose bank records were obtained because they bought a gun, they were at the insurrection, and they were going to come back. The fact of the matter is, we are once again here on a completely sham rationale. There was no First Amendment or Fourth Amendment violation around January 6th. No. This is simply another effort to whitewash what happened on January 6th. One of the members of the committee calls those who were convicted of crimes hostages, while there are actual American hostages sitting in Gaza right now under captivity of a terrorist organization. And we're supposed to equate the people sitting in jail who rioted and attacked this Capitol, we're supposed to equate them with these hostages. Mr. Chairman, you continually say that it used to be that both parties agreed with the First Amendment. It didn't used to be. It is. It remains the case. We all agree with the First Amendment, but the problem is that the First Amendment is not absolute. It does not protect any single thing anyone says, and there are limits, and that's important. And what this committee has been trying to do for the last year and a half is to chill the federal government from monitoring what is going on social media and otherwise out there so that misinformation and disinformation can run rampant on Elon Musk's social platform and every other social platform so that the Republicans, can benefit from it in November's election. That is why this committee exists.
The time of the gentleman
and we have gotten no evidence to support any of these allegations.
The chair recognizes the gentleman from South Carolina.
I yield to the chairman such time as he may consider.
I appreciate that. I think the gentleman from New York just said that we're trying to chill the federal government. I don't know if it's ever been said that way. It's always the government trying to chill Americans' rights and chill Americans. I've never seen anything. It's called projection. I've never seen anything like. But guess what? You know who was opposed to how the FBI and the Bank of America did this thing when they asked for this information? You know who was opposed to it? 3 FBI agents. The guys on the case. George Hill, Bonavolanta, Steve Jensen, all testified to the committee that it was wrong. And guess who else said it was wrong? Chris Wray said this: we recalled this information to avoid even the appearance of any kind of overreach. So even the FBI, who has systematically violated Americans, who's this FBI who said, if you're a pro-life Catholic, you're an extremist. If you're a parent going to a school board meeting, you're a terrorist. Even the FBI said, this is ridiculous. And they pulled back. 3 agents testified. So, I mean, and somehow the government is the one who chills American speech when they pressure big tech to censor, when they ask banks to give them. That's chilling speech, and we've seen it first. Dr. Peterson's seen it in his own country, and now it's coming here. That's what we're concerned about. I yield back to the gentleman. Thank him for yielding.
Thank you, Chairman, and I would echo that. I'm glad that Thomas Massey started off with a recitation of the Fourth Amendment.
Thank you very much, Ms. Presley. I want to get back to this photograph here that I got cut off from before. You, Mr. Bobulinski, called a number of people liars, 6 FBI agents.
I did not call this as 6 FBI agents liars.
I'm talking. If you go to page...
Well, you know better, Mr. Goldman.
Okay, go to page 174 of the transcript, and you said it's not an accurate statement. It's a lie related to an FBI report.
I didn't call them liars.
Sorry, I don't have time. Be quiet. Now, this is a photo that was provided by Cassidy Hutchinson after you called her a liar when she said that you met with Mark Meadows and received an envelope. Do you see this photo? Do you acknowledge that is Mark Meadows in the red hat?
Didn't you tell me to be quiet? I don't.
I asked the question. Do you acknowledge that that's Mark Meadows?
I don't. Maybe your person can walk it closer so I can see it?
Mr. Chairman, would you indulge, just since he's
I
not
mean,
answering the question,
you're
he's
15
filibustering?
seconds over, but it may help.
Well, let me just ask it very briefly. Is that you and Mr. Meadows by Secret Service cars with you in a mask?
Are you kidding, Mr. Goldman? I'm sitting 20 feet away from it.
Go
It's
up to him, please. Go
All
right up to
and
him.
your time's expired.
Okay.
Maybe Mr. Swalwell will give you some time.
Could he just answer the question?
He can answer the question, right?
So what I see in this picture is a Secret Service agent 5 feet from me with a full mask on, and a Secret Service agent sitting in a Cadillac Escalade with all the windows up with a full mask on.
Is that
So you're making it a
talking
big
to
deal.
the person in the red hat?
It's the back of his head. I don't.
Is that you talking to the
Why don't
person
you ask
in
me
the red
this,
hat?
Mr. Goldman? Did I meet Mr. Meadows at a Trump rally in
Answer
Rome,
the
Georgia? I
question.
did. I acknowledge that.
Is it you?
Mr.
you do.
Goldman.
I did.
Mr.
Of
Goldman,
course I did.
But Cassidy Hutchinson is a liar.
Cassidy Hutchinson's
Thank
a
you.
liar
Back.
because
Time
she
is
said
expired.
that he handed me an envelope. Mr. Meadows didn't give me a single thing.
Now, Chair recognizes.
Glad we have the clear
No,
story.
your
Mr. Chairman.
time's expired. Maybe Mr.
Gentleman yields back. The chair now recognizes Mr. Goldman from the state of New York for 5 minutes.
Thank you, Mr. Chairman. Secretary Mayorkas, thank you for being here once again to endure the completely uncalled for, unwarranted personal attacks from my Republican colleagues. I want to get into some of what they have been saying because it's truly shocking that we are where we are. On the one hand, my colleague from Florida says that all Democrats want to do is throw money at the problem. Mr. Pfluger just said this is a policy issue, it's not a money issue. Okay. Is the Senate bipartisan bill that you worked on, along with the second most conservative Republican senator in the Senate, an independent and a Democrat, that was endorsed by Senate Republican leadership, a policy bill or an appropriations bill?
It is both, Congressman, it is both an appropriation bill and an immigration reform bill, and fixing what everyone agrees is a broken system. It would provide us with new legal authorities that are much needed and would really advance the security of the border.
And one of those critical revisions is in the asylum process. I know this is not under your purview, but do you have any sense of how many asylum applicants ultimately are granted asylum in this country?
Congressman, it of course depends on the demographics, but as a general rule, I believe it is approximately 20-25% ultimately receive asylum, but I would want to verify that statistic, and I probably shouldn't share it given my uncertainty.
Understood, there are different numbers, but it takes at least 5 years and perhaps as many as 10 years for a case to be completely adjudicated. Is that right?
It takes many years until a case is finally adjudicated.
So let's just say, hypothetically, that we had an asylum processing system that could process any applications within 90 days, 6 months. Am I correct that that means that 75 to 80% of the people who apply for asylum would not get asylum and would be returned to their own country?
That would enable us to remove people far more quickly. You are correct, and that would make a sea change of a difference in our ability to enforce the southern border of the United States.
And is it your view that if that were the case, that there would not be an incentive for anyone who knows that he or she may not qualify for asylum to come to this country knowing that that person would be able to make an application to get a work authorization and stay here for at least 5 years to work? Is that correct?
That is, Congressman.
And that, of course, creates a tremendous incentive for people to come across the border. The problem is not our credible fear standard. The problem is not the policy of asylum. The problem is that we don't have the resources to process asylum applications as expeditiously as is necessary. So no one over here is talking about throwing money at the problem. We're talking about solving the problem. And in the Senate, they tried to solve the problem. They tried not just with appropriations, but with a policy bill. Unfortunately, the Republicans have put politics over our border security. They want chaos in order to win an election rather than to solve the problems. You don't have to take my word for it. Let's quote Donald Trump, who said that he sabotaged the bipartisan deal to secure the border because, quote, it made it much better for the opposing side, unquote, and that he had stated that he, quote, killed, unquote, the deal. Senator Lankford himself said that a top Republican told me that if I try to move a bill that solves the border crisis during this election year, he will do whatever he can to destroy me. He said, I do not want you to solve this during the presidential election. There was a policy bill. There was a policy change that would have significantly addressed the problems at the border. And instead, you all on the other side of the aisle sabotaged it, where you baselessly impeached the secretary who's trying to solve our problems at the southern border because you want to win it. You want to win in November.
Gentleman's time has
You
expired.
don't want to solve the problem.
The gentleman.
I recognize Mr. Goldman.
Thank you, Mr. Chairman. I'm going to take a minute just to answer the question you keep asking, which is, what is the business of the Bidens? Not surprisingly, you consistently and continually refer to the Bidens, the Biden family, and you never refer to the individual names. So let me just help you out with telling you what the professions are of the Bidens. Hunter Biden was a corporate governance lawyer appointed by George Bush to the Amtrak board and then served on a number of corporate boards and investment firms. Jim Biden, you can put that down for a second. Jim Biden is a businessman. Joe Biden is the President of the United States and has been a public servant and elected official for the better part of 50 years. Now, Hunter Biden, you may want to discuss what his business was and whether he was equipped to be part of an investment firm to provide services based on his experience, but that has nothing to do with your jurisdiction or the impeachment investigation, because you cannot link any of his business dealings, A, to any foreign government, which he was never paid by, unlike Donald Trump's and Donald Trump's family, or B, to the President of the United States. And that's why your impeachment investigation is a spectacular failure. Now let's turn to the issue of this hearing. In the opening statement, the chairman chided Democrats for adding Russia to a hearing on political warfare. It's truly remarkable, given the following facts. First, we know that Russia used political warfare to interfere in the 2016 election on behalf of Donald Trump. We know that from the Mueller report, which my colleague from Texas just referenced. The Mueller report never, of course, said there was no collusion. It just stated that there was insufficient evidence to prove a criminal conspiracy. But there was plenty of evidence of collusion, including just a few, Donald Trump Jr. eagerly meeting with Russians to get, quote, dirt, unquote, on Hillary Clinton, Donald Trump asking Russia to hack into Hillary Clinton's emails, which they did, and Paul Manafort, the campaign chairman, giving internal polling data to a Russian spy. And in fact, Special Counsel Mueller stated that the Trump campaign knew about the Russian interference, welcomed it, and used it for their benefit. But importantly, Special Counsel Mueller also charged 24 Russians with interfering in the 2016 election through a hacking scheme and social media. Let's also point out that Chairman Comer and Chairman Jordan have both stated that the best evidence of high crimes and misdemeanors by President Biden was a thoroughly and repeatedly debunked theory of bribery that was planted in this committee by the Russian government through an FBI source. Third, Republican chairmen of our national security committees in the House have stated that Russian disinformation has infiltrated the Republican Party and is parroted on the House floor, as more than half the Republican Party has taken the side of Vladimir Putin against our democratic ally in Ukraine. Now, Professor Snyder has done a masterful job explaining how the CCP's efforts to engage in political warfare is based on Russia's previous efforts to do so. And in fact, China's primary means of doing so is to amplify Russian disinformation and political warfare. And here we have two spies, one alleged Russian spy, one Chinese spy on the top, Gal Luft, and one alleged Russian spy on the bottom, Alexander Smirnov. Alexander Smirnov is the one who planted the false information about the bribery that the chairman and both chairmen have said is the best evidence of wrongdoing by Joe Biden. Gal Luft is the Chinese spy who the chairman has said was a very credible witness. So you cannot discuss the CCP efforts to engage in political warfare without discussing Russia's. But not surprisingly, the party of Putin in the majority wants to do just that. Let's just make one reference to the Chinese spy.
Mr. Chairman.
We're supposed to talk about...
Mr. Chairman.
Please stop my time.
Stop the clock. Chair recognizes Mr. Sessions.
Mr. Chairman, I think that was a personal remark at me and my party. I think it's inappropriate, and I would ask that the gentleman's words be taken down.
I don't think the gentleman mentioned your name, did he?
He said the party of, he referred to my party as the party of Putin, and that is a personal slanderous statement.
No, it's not.
A statement about a party, by definition,
I would ask that his
not about
words
a
be
person.
taken down.
A statement about a party is, by definition, not a party about a statement about a person.
The committee will suspend.
I do get to defend myself, Mr. Chairman, and what I would say is that
We've suspended. Do you wish to take down what you said?
No, I do not.
Okay, well, we suspend.
And I don't, because it's not referenced any individual member of Congress, which is the only reason why words are taken down.
The chair has ruled that, unfortunately, since his remarks weren't directed towards a person but rather a party, then they cannot be taken down. But I will remind everyone about the decorum that we have all agreed to abide by, as well as the purpose of this hearing. It's about the Chinese Communist Party's influence in America. And I think,
Mr. Chairman, if I could
Goldman,
have
you have
time
14
restored.
seconds.
No, I'd like my time restored to 20 seconds,
you
because
have
I would
20
like to
seconds
talk
then.
about
All right.
what you just said is this hearing, the point of this hearing, which is the CCP. So if I could get my time back to 20 seconds, I just have one more point to make on that.
20 seconds.
Thank you.
19.
So let's talk about the CCP's infiltration. After Gal Luft was arrested, and a simple internet search would show that he was arrested, the chairman said that he was a very credible witness on the Biden family corruption. Do you know what else he was charged for? He was charged for making false statements to law enforcement about the very information that the chairman claimed to be credible.
Time's expired.
Just like
Chair now
Alexander
recognizes
Smirnov,
Mr. Burchett from
the
Tennessee.
Russian agent was
Chair
charged with false
recognizes Mr.
statements.
I'm not quite sure.
Yes, for sure.
And I just want to ask one other quick question. Given how Hakeem Jeffries has handled, both Speaker Johnson and the caucus, what do you think this foreign aid fight has told us about how a Hakeem Jeffries speakership would look?
I think it shows us how effective, how substantive, how meaningful it would be, and how much he and the Congress would prioritize the people and policy over political shenanigans.
Gotcha. And do you anticipate the same kind of procedural fights in a Democratic majority that Republicans have had to grapple with, or do you think he can maintain a little more unity?
No. There will be none of the procedural fights like this. This is the most dysfunctional Congress that we have seen in modern history. All of the norms and regular order has been destroyed because there are a few extremists who are willing to burn the House down if they don't get their way. It's not enough to vote no. They need to make sure that they get their way, which doesn't work when you're in a narrow majority, and certainly doesn't work when you're in divided government, because you have to recognize that you don't control all three entities that are required to pass legislation. And the fact that there's an extremist wing of the Republican Party that won't accept that they don't have total control over our government has ground this Congress to a complete halt, except when Democrats join in to get the essential work of the Congress done. If this passes today, then it will be yet another example of the work of Congress getting completed and accomplished solely because Democrats put country over party.
Would you be willing to vote to save Mike Johnson if he was vacated?
No, we'll have to see if they actually do it. I think it would be a terrible political move, not to mention would again cause more chaos and disorder in this institution. We saw in October that there's no easy fix, and that's because the problem is not the speaker, the problem is the party. It's like a terrible golfer getting new clubs to try to get better. The problem is not the clubs. The problem is not the clubs, it's the swing.
Does sacrificing himself for the Ukraine aid make you more likely to help him?
Well, I think everyone on our side recognizes that in the face of significant opposition and threats from extortionists on the extreme MAGA wing of his party, that he has stood up and to do the right thing because he recognizes that Congress and the House must govern, and that's what our role is. So,
thank you, Congressman. Thank you very much.
Really nice.
Would you be willing to vote to save Mike Johnson if he was vacated?
No, we'll have to see if they actually do it. I think it would be a terrible political move, not to mention would again cause more chaos and disorder in this institution. We saw in October that there's no easy fix, and that's because the problem is not the speaker, the problem is the party. It's like a terrible golfer getting new clubs to try to get better. The problem is not the clubs. The problem is not the clubs, it's the swing.
Does sacrificing himself for the Ukraine aid make you more likely to help him?
Well, I think everyone on our side recognizes that in the face of significant opposition and threats from extortionists on the extreme MAGA wing of his party, that he has stood up and to do the right thing because he recognizes that Congress and the House must govern, and that's what our...
And to be clear, that the witness did appear to testify on the date that my colleague stated he did not come to testify. He was here, and the White House and this committee staff did not work out the terms of that interview. So I don't want it to appear that he has shirked his willingness to be a part of any hearing or any testimony or any interview by this.
Chair recognizes the gentleman from New York.
Thank you, Mr. Chairman. We are seeing a pattern here now, a year and a half into this Congress, and we see it with the impeachment investigation, and we are seeing it starkly here. Let's make a lot of really bold allegations and then try to weave in and mislead some evidence to justify them. It certainly happened in the impeachment, and it is happening here again, because in order to, quote, coerce or censor, then that means, A, whoever the private company that receives the communication from the government must feel coerced and act on that information, and B, they would not have done that but for the government intervention. And the problem that we continue to have with my Republican colleagues is they can get the first thing, but they never get the second. That is why evidence is important, and that's why we rely on evidence. So when colleagues over on the other side of the aisle talk about a TikTok ban, they are misrepresenting what the bill did. The bill required ByteDance to divest from TikTok, not to ban TikTok, and that is so consistent with all of the cherry picking of these emails that we have seen here today. I want to bring up another example, which was actually the focus of an entire hearing on this topic, but has not been mentioned once today. And that is the email from Clark Humphrey to Twitter related to Robert F. Kennedy Jr.'s tweet about blaming Hank Aaron's death on the COVID vaccine. And this was the center of the Republican case up until today, and now we're moving on. And I want to just stress why. Clark Humphrey wrote, wanted to flag the below tweet, and I'm wondering if we can get moving on the process for having it removed ASAP. Oh my goodness, coercion. That is censorship. It's some industrial complex. But you know what the problem was? It wasn't taken down. It wasn't taken down. Twitter received that email from the White House and did not act on it. Mr. Seligman, is there possible to have coercion when someone does not do what the other person asks?
No.
Now, we've heard a lot on the other side of the aisle. I think my friend Mr. Stubbe talked so much about March 2nd, all the emails to Amazon and trying to ban books. Well, we were not allowed to enter into the record some of the testimony from the employee who received those emails at Amazon, but I'm going to go through this transcript because this employee was asked about that email. Even though you anticipated that you might be asked to remove content when you had a live conversation with Mr. Flaherty, you in fact were not asked to remove any content. Question? Answer, that's my recollection, yes. So I just want to be clear, to your knowledge, did anyone from the US government, including Mr. Flaherty or Mr. Slavitt, both of whom are witnesses here, ever coerce Amazon into removing content from its platforms? No. The answer, as the ranking member pointed out with so many other companies, was that they made their independent decisions what to do with the content based on information provided from public health experts like Mr. Slavitt and the CDC and how that applies to their own policies. So you cannot have a First Amendment violation when a private company is making its own independent decisions, as every single company as part of this investigation did. So what is this all about? It's not actually about proving a First Amendment violation. What the Republicans want to do with this committee, because we've had hearing after hearing after hearing about some bogus
First Amendment violation by private companies is they want to chill the government from actually interacting with the private companies as we come upon an election in November of 2024. Russia interfered through social media in 2016. Russia tried to interfere in 2020, and you can bet Russia is trying to interfere in our election in 2024, and the only way that these social media companies can know that is by being provided with information from the United States government and their law enforcement investigations, and if that can't happen, then Donald Trump and these Republicans benefit because Russia will help them. That is why we're here, and that is why this is bogus. And I yield back.
Time of the gentleman expired. Gentleman from North Dakota is recognized. I appreciate the gentleman yielding. Chill the government? Oh my God, that's almost as crazy as what Justice Ketanji Brown Jackson said in the arguments in front of the Supreme Court when she said to the Solicitor General from Louisiana, "Counselor, your position has the First Amendment hamstringing the government." This is not about. This is not about. I know the gentleman from New York is sharper than that. I know that Professor Zawicki. Mr. Goldman.
Mr. Chair, you can only, someone has, as a point of order, time can only be yielded to you if the individual remains here during the person.
Yeah, you got to cite a rule, but we can also get Mr. Armstrong back if you're.
Then you should do that.
You're going to do that. Okay. But you need to cite the rule. If not, we'll proceed. When he comes back, we'll make sure he gets back.
Mr. Chairman, will you just yield quickly for a brief response?
It's my 5 minutes. No, it's my 5 minutes, and when I'm done.
Okay, so you're going to attack me and not let me respond?
No, I said I know you're smarter.
You said my name.
I was complimenting the new.
You said my name. You said I know you're smarter than that because I did not say anything about the First Amendment being used to chill the government. I said you in this committee are trying to chill government agencies. That's very different.
We're trying to protect the First Amendment. We're trying to protect the government from chilling American speech. Let the record show the gentleman from North Dakota has returned to his spot on the committee. Professor Zawicki, let's reference the email that Mr. Goldman brought up. And he said that the RFK Jr. tweet wasn't taken down. But I think this whole chilling effect is proven by this email, because there were two sentences. The first sentence said, wanted to flag the below tweet, and I'm wondering if we can get moving on the process for having it removed ASAP. So these guys, actually Ms. Humphrey, who works with them, said to Twitter, take this thing down. We don't like what RFK Jr., our political opponent, subsequent political opponents saying, take it down, right? And Mr. Goldman says, oh, no problem, they didn't take it down. But there's still a concern about chilling speech, right?
Exactly right, Mr. Chairman. And that's exactly what the problem here is there's this obsession with protecting the government's free speech rights. But we need to be worried about protecting people's rights. We need to be worried about protecting my rights. We need to be worried about people's rights to speak and to hear information that is relevant to their lives. And so if we're concerned about chilling speech, we should be concerned about chilling the speech of private citizens through the government overreach.
Now, I want to ask you about this. The next sentence. So, take down this tweet ASAP. Mr. Goldman says, oh, they didn't take it down, so there's no problem. But the next sentence says, and then, if you can keep an eye out for tweets that fall in this same genre, that would be great. That's the real chilling impact. Oh, we caught you. We don't like this tweet. We don't like what it conveys. Take it down. They don't take it down. But now, in the back of their mind, they're saying, oh, you know what? I better be on the lookout for anything else, or I'm going to get another call, another email. Mr. Flaherty's going to call me. Mr. Slavitt's going to call me and say, what the heck are you doing? He's going to be outraged. He's going to pressure us, which all happened. So the second sentence is the chilling effect in that email. Is that right?
Yes.
This is just ridiculous. Oh, and let's go to the Amazon communications, because this was speech that was changed. This was content that was changed at the request of the guys in the Biden administration. The impetus for this request is criticism from the Biden administration about sensitive books we were given prominent placement to. So we're going to create a new do not promote class for anti-vax books. So they demoted these books. So a direct result of they said it themselves. The impetus, the catalyst for this is the guys at the White House. That's not just chilling, that's actual action taking place at the request of government to limit speech and who gets to see it.
And I would add, this isn't the government providing public information about issues of health. This is the government engaged in an ongoing, secretive process that we've only discovered through discovery in that case and through the hard work of this committee subpoenaing these private actors, a secretive scheme to target named individuals for suppression for speech. And we don't even know if it's going on.
Yeah.
That is a big difference between the government expressing its opinion and targeting people secretly to remove their speech from the public forum.
Take down this tweet ASAP, the White House. And be on the lookout for any other thing in this genre.
Exactly.
That's a direct attack. That's as big a chilling impact as you can have on speech, coming from the office of the president, the White House itself. I appreciate the gentleman yield back to Maynard.
Mr. Chairman, point of order.
Gentleman is recognized for.
I just want to clarify that it is Rule 9F that requires a member to be actually present in order to possess a 5-minute period of questioning.
Yeah,
So in the future, if we can ensure that when members yield that they remain in the room, that would be helpful.
Great.
Thank you.
Gentleman yields back. Chair now recognizes the gentlelady from Wyoming is recognized.
Well, thank you. And if it seems like there might be a dog in this hunt on the other side, what you need to understand is that Mr. Goldman, the novice representative from New York, actually does have a personal stake in this case. He has stated that he has been involved with the Bragg case, helping to prepare Mr. Cohen for his testimony. So he is quite closely aligned with an admitted and convicted liar and perjurer. He's also paid the Judge Merchant's daughter's firm over $150,000 for her services. So I think we've got quite a conflict of interest from Mr. Dan Goldman, the novice representative from New York. And just one other thing to keep in mind when considering the hostility from the folks on the other side of this aisle is that the ranking member of this
Mr. Chair, I would move to have that
was Jeffrey
stricken from the record,
Epstein's
to have
fixer.
that phrase taken down.
The ranking member was Jeffrey Epstein's fixer. So I think that might give you
Excuse
some
me,
idea of
I
why
would
you
ask
see this
that
hostility.
Hang on,
statements be taken down.
The ranking
to
member is
Mr. Goldman.
recognized.
I would ask that the statements regarding the conflict of interest related to Mr. Goldman be stricken down from the record. Engaging in personal personalities.
In your 14-minute and 14-second opening statement, you called the former president, current candidate for the office of president of the United States, all kinds of names. I think
he's not a member of this committee.
I understand he's not a member,
and
but
that's what I'm asking.
A former president. What I'm saying is we should all be careful about it. I think the gentlelady from Wyoming was just stating facts that are in the news report.
She accused him of a conflict of interest on the committee during the hearing. I ask that that be stricken down.
Gentlelady's point of order is overruled. The gentlelady from Wyoming is recognized.
Thank you. Mr. Hamilton, would you agree that gag orders on trial participants were created with the intent of securing a defendant's right to a fair...
Gentleman's recognized for a minute and a half.
Thank you very much, Mr. Speaker. I rise today as a proud American Jew who steadfastly supports Israel's right to exist as a democratic Jewish state and its right to defend itself after Hamas's barbaric and unprovoked attack on October 7th. The United States must continue to support Israel to defeat Hamas, release the hostages, including Americans stuck in Gaza, and provide all funding, weapons, and intelligence necessary in order to do that. And that is President Biden's clear policy as well. This bill does not do any of that. It does not support Israel. It does not provide any additional funding, any additional weapons, nor any additional support for Israel. And even though Republicans delayed for 6 months, I was pleased when this body finally, bipartisanly, voted to support Israel with the supplemental aid package several weeks ago. But this bill is designed to undermine that bipartisan support, which Israel desperately needs. And as a Jew, I am frankly sick and tired of the Republican Party using Israel as a political weapon to divide us, which aids Hamas, Iran, and Israel's enemies. So to my Republican colleagues, I have one simple request. If you truly care about Israel, please stop using it as a divisive political pawn. Just stop. I yield.
Nature of a substitute to the contempt report as offered by Mr. Comer of Kentucky.
Without objection, the amendment is considered as read.
I reserve a point of
order. I recognize myself for 5 minutes to explain the amendment.
Great. And I reserve a point of order against the amendment. Thank you.
As I said in my opening remarks today, the Department of Justice informed the committee that President Biden is asserting executive privilege over the audio recordings of his interviews with Special Counsel Hur. Until today, the White House had not asserted any privilege and, in fact, bragged that President Biden had not asserted executive privilege in the interest of transparency. My amendment simply amends the contempt report to reflect that the White House has now asserted a privilege regarding these recordings. Though I believe this is a miscalculated and invalid assertion of executive privilege, my amendment would make the contempt report reflect today's developments from the Department of Justice and the White House and reflect the record as of today. Do any other members wish to speak on this amendment? If not,
Yes, Mr. Chairman.
Chair recognizes Mr. Goldman.
This is the part of the problem why you can't give the Republicans nice things. Because it's never enough. And it is true that the President Biden has not asserted executive privilege over the entire subpoena, effectively, that they responded to, but for the audio, which is redundant because you have the information. There's no point in having the audio other than for political partisan purposes. And I understand how my colleagues get irritated because every time you bring up something about President Biden, we bring up something about President Trump. But the reason we do is because in every single circumstance, what President Trump did was so egregious compared to what President Biden may or may not have done. Donald Trump asserted executive privilege over everything, over just about everything while he was president. It was a reflex of his. And here you're complaining that Joe Biden finally asserted executive privilege over material that you cannot possibly enumerate a legitimate legislative purpose about. There is not one. You cannot, nobody can tell me, I know you say that what the intonation is why you need this, but I can assure you every court of law would tell you that the intonation of the voice as opposed to the words on the page is not a legitimate legislative purpose.
Mr. Chairman, would you yield to me, Mr. Chairman?
I think it's
is it
Mr. Goldman's time.
Oh, I'm sorry. I thought you had yielded, Mr. Goldman.
No, that's okay. So I do think that the executive privilege assertion is yet another reason why the contempt motion fails, as it has previously, and that there has been contempt proceedings have been called off when administrations, the last administration, has asserted executive privilege. If you would like to challenge the executive privilege, you may do so. You may go to court. But to hold the Attorney General in contempt over something that the President has asserted executive privilege is completely illegal and improper. So in addition to the jurisdictional problem, you also have an executive privilege problem because you can't hold someone in contempt for something they have no control over, whether it's asserted executive privilege. You're welcome to go to court. You can go to court and challenge the assertion of executive privilege. That has happened before. Don McGahn has a very well-known case now that was litigated because he asserted, the president asserted executive privilege over him. But this is a legitimate use of executive privilege. And if you disagree, go to court. But this contempt hearing and this contempt motion is completely nullified by the assertion of executive privilege.
Would the gentleman yield?
Yes, I yield to Mr. Raskin.
And thank you again for your clarifying analysis of the contempt citations. Some of our colleagues invoked the cases of Dan Scavino and Peter Navarro and Steve Bannon. We're talking about people in those cases who never produced a single document and never spent a minute before the committee. They completely blew off their subpoenas, which is why they were held in contempt by the Congress, and then they were subjected to criminal prosecution for it. Now, you compare that to the case of the Attorney General of the United States, who produced precisely the document that was being sought, all 250 pages of it. Then there's a bait and switch, and then it said, oh, well, no, now we want the audio tape. He has a very reasonable invocation, I assume, of executive privilege, although I haven't looked at it. But in any event, not anything that you would base a criminal arrest upon, given that he overwhelmingly complied with the demands of the committee. And I think everybody's got to concede that. And if you want to make the argument splitting hairs that, well, through some intonation or accent in the audio tape that a high crime and misdemeanor might emerge, then please make that argument. If somebody could even offer us a hypothetical of how we could ground this in the jurisdictional authority and the legitimate exercise of power of this committee, explain how the audio tape could reveal some intonation or accent that would produce the holy grail that you've been looking for 18 or 19 months, which is a high crime or misdemeanor. And so far, nobody's uttered a peep about it. Thank you for yielding, Mr. Goldman.
I yield back. Without objection, the amendment is considered as read. I reserve a point of order. The gentleman from New York is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. This amendment details and enumerates exactly what the subpoena requested and exactly what the Department of Justice has done in response to that subpoena. And I will summarize that the subpoena of February 12th requested all documents and communications, including audio and video recordings, related to the special counsel's interview of President Biden, as well as the special counsel's interview of Mark Zwanitzer, who is the ghostwriter of President Biden's book or books. 3, the documents identified as A9 and A10 in Appendix A of Mr. Herr's report. And 4, all communications between or among representatives of the Department of Justice, including the Office of Special Counsel, the Executive Office of the President, and President Biden's personal counsel referring or relating to Mr. Herr's report. Obviously, it goes almost without saying that that last request is completely improper, would be deliberative process and executive privilege, although I don't think they determine executive privilege, but there is no basis for Congress to get internal communications within the Department of Justice about decisions they have made. And if you have any question about that, you should go refer back to your favorite former president and his administration, where they use that repeatedly. In response to the subpoena, the special counsel, or rather the Department of Justice, provided the unredacted report, as you know, the transcripts of the interviews of President Biden and Mr. Zwanitzer, provided the documents identified as A9 and A10. So really the only thing that could even be considered as a legitimate request that the Department of Justice withheld is the audio recording of the 2 interviews, about which there already is a transcript. And so the question that this amendment begs is, if the majority thinks that giving substantially the entire subpoena response, responding with substantially everything that the subpoena asks for warrants contempt of Congress, what does the majority think about somebody who, I don't know, refuses to respond to a subpoena altogether? Maybe Chairman Jordan has a response to that? Mr. Biggs? Mr. Perry? Because I'm pretty sure that they each received duly authorized subpoenas, and I appreciate that the
gentleman yield?
Georgia, in 1 sec, I will. I appreciate that the gentle lady, I will, 1 second. The gentle lady from Georgia, with her esteemed legal knowledge, determined that the January 6th committee was not a legitimate committee.
when unfortunately a number of actual courts of law determined that it was. So those subpoenas to members of Congress were duly authorized subpoenas. And if Merrick Garland is going to be held in contempt and is going to be threatened with inherent contempt and sent to a non-existent jail in the basement of the Congress, then what is going to happen to those witnesses who just outright defy congressional subpoenas? Because I do think the majority ought to be careful about the precedent that it sets, because, Ms. Luna, I am happy to reinstitute right now with you inherent contempt. And I can assure you that when you consult with the rest of your party, nobody will want it, because it will be much, much worse for you than for the Democrats.
Will the gentleman yield?
I'm happy to yield, yes.
I'd just like to point out that inherent contempt or contempt, as to my understanding, can't be brought forward in a new Congress, even if it's been a past violation. I know because I actually inquired on Cohen today.
Oh,
so
yeah,
just
no,
so you're aware.
I'm not suggesting that we bring inherent
Well, I'm just
contempt
to clarify.
for any past subpoenas. I'm talking about the precedent that you are
Are you
setting.
now willing
Like
to yield,
Mr. Biggs? Yes, of course.
Mr. Chair.
Thank you for yielding to me. First of all, you made a personal reference again to Mr. Jordan, about myself, and about Mr. Perry, which we had agreed that we wouldn't do. But I'm going to respond to you. We asserted that we had not received service. And
Okay.
that's how we
So
responded.
your response
End of
is that you
story.
didn't receive service of the subpoena. I just want to be clear. That's why you didn't comply?
Gentleman's time's expired. Gentleman's time's expired.
I thought so. I'll yield.
Do any other members wish to speak on the Goldman amendment? Mr. Chair recognizes Mr. Fry from South Carolina for 5 minutes.
Thank you, Mr. Chairman. I oppose this amendment by Mr. Goldman. Mr. Goldman's amendment is just an attempt to distract from the very obvious.
Mr. Goldman.
Thank you, Mr. Chairman. In preparing for this markup, I wanted to do a little bit of work to understand why the Oversight Committee is trying to hold the Attorney General of the Department of Justice in contempt. The Oversight Committee does not have jurisdiction over the Department of Justice. The Judiciary Committee does, and I understand the Judiciary Committee held a markup of their own today on the same exact contempt motion. And so I thought, oh, well, let's take a look at the impeachment investigation. It must be coming from that. So I looked at the impeachment resolution that was passed on December 13th, 2023, HRes 918, and it refers to a memorandum dated September 27th, 2023, from the three chairs that was entitled Impeachment Inquiry. It's 30 pages long, this memorandum, and there isn't a single mention of classified documents or Special Counsel Robert Hur or Joe Biden possessing classified documents. And so, Mr. Chairman, I would ask what on earth we are doing here in the Oversight Committee when we have no jurisdiction to be holding the Attorney General in contempt. And I'll happily yield to you if you would like to respond. Doesn't want to respond.
I'll respond.
Go ahead, Mr.
Yeah, we
Gosar.
actually set the precedent in my first term, our second term, in regards to holding Mr. Holder accountable in contempt in this very office or this very committee. And
yeah, but that was related, if I may just reclaim my time, that was related to an investigation that this committee was doing. What the Special Counsel Hur was investigating has nothing to do with anything that this committee is investigating. I understand that the impeachment investigation that you all ran was such a massive flop and a bust that you would like to try to distract from that complete humiliation, but doing so outside of your jurisdiction is probably not the best way to do it. And in reality, not only was this absurdly postponed so some people could go prostrate themselves in front of their dear leader today in New York, and we are now at 10 o'clock at night, But we have absolutely no reason to be here. We have no jurisdiction over this matter. It was properly in front of the Judiciary Committee. The Judiciary Committee will do what they want to do over there in the Department of Justice. But it is truly a reflection, an unfortunate reflection, of how desperate the chairman is to distract from what was a monumental bust of an impeachment investigation.
Would the gentleman yield for a question?
So, not quite yet, Mr. Biggs. I'll get to you.
Thanks.
And so I would urge the chairman to explain to all of us what, other than pure distraction from the impeachment investigation that seems to be over now, as to why we are here at 10 o'clock at night marking up something over which we have no jurisdiction. Mr. Biggs, happy to yield to you.
Thank you. Thanks so much. And Mike, I guess my question is on your jurisdiction position, your position that we lack jurisdiction. I'm wondering if you would if what you think of Rule 10 of the committee's jurisdiction, and also
I don't have Rule 10 memorized, Mr. Biggs.
We'll take a look at it because it says. Let me see if I can just give you a slight.
Go ahead and read it, just like you can read the transcript.
Yeah. Well, I would prefer actually seeing the audio of the transcript, hearing the audio of the transcript. Anything at any time. That's the language that's used in Rule 10. Take a look. It might be helpful when you're making a lack of jurisdiction argument. The other thing is,
what is anything at any time, Mr.
Take a look in Rule 10. I think you'll change your position. Let me ask you this other question.
Would the gentleman yield?
Well, I'll reclaim my time and yield to Mr. Raskin.
I wanted to thank the gentleman from New York for his trenchant remarks here. Would you think it's fair to say that it's not only way outside of our jurisdiction, but it's also redundant, given that the Judiciary Committee, which has jurisdiction, has already acted?
Well, of course. This is already going to go to the House floor regardless of whatever we do. So it's a shame that this committee feels so desperate to latch on to some victory that we need to hold a completely redundant, unnecessary markup over something that we have no jurisdiction. Mr. Chairman, I
and
yield
the
back.
gentleman's time's expired. Does anyone else seek recognition? We have some amendments to be offered. Can we start with the amendment process? Is everybody okay with that? I will begin. I recognize myself to first offer an amendment. The clerk will distribute the amendment to all members. Everyone have my amendment. The clerk will please designate the amendment.
Comments with some economy of time. Do you wish to respond to the last barrage?
Well, only to say that nobody disputes that when a law enforcement is fired upon, that they have a right to fire back. The point is that everything that created that situation was incompetent, unnecessary, and reckless. And it defied the law because, as a former assistant, you know the Fourth Amendment cases that allow either a no-knock or what I would call a tap-and-go type entry with no real waiting for someone to come to the door are only justified by exigent circumstances that do not exist in this case. So, in my opinion, as a former U.S. attorney, this was a completely illegal search because of the forced entry and the lack of time they gave the occupants of a fairly large home to get up at 6 in the morning. The law requires them to wait for enough time, for a reasonable amount of time, for someone to come to the door and admit them in.
And 50 seconds.
I assume the local prosecutor.
My time. Yes. You've had plenty. And Mr. Cummins, I appreciate that very effective rebuttal. Here's what's interesting to me as this hearing evolves. I hear Mr. Goldman defending the practice that he says is engaged in every day. And earlier on, the ranking member invoked the Breonna Taylor episode, and I've just been sitting here reviewing it. Mr. Goldman said earlier on, well, this wasn't a no-knock warrant. Okay, what's the difference in the situation if they knock and they blow in, in 20 seconds, or it's a no-knock? In fact, in the Breonna Taylor case, that wasn't a no-knock warrant. They said they knocked and waited 45 seconds, and they went in. Mm-hmm. Here's something that's interesting. In the Breonna Taylor thing, she was killed on March 13, 2020. In that, it was execution of a search warrant, just like this one.
Murder.
Time belongs to the gentleman.
First police officer was fired June 20. In September 2020, Louisville entered into a $12 million settlement with the family. Have you been made any overtures by the Department of Justice to settle liability against the government on behalf of Mr. Malinowski's family?
No, sir.
In September, also, one of the police officers was indicted for willful endangerment or wanton endangerment. A second officer was fired in January 2021. A third officer was retired in April 2021. Oh, I left out. In October 2020, grand jury testimony was leaked. Later in 2021, the DOJ indicted 4 officers, and even now it's retrying one who were for the hung jury. I don't understand the difference. I don't understand my colleagues' reaction that.
If you would yield, I could share the difference with you.
You've talked for a long time. I'm going to talk during my time.
Okay, then I would tell you the difference.
Maybe you can provide context for your egregious double standard. No one that I recall on the Republican side, when the Breonna, by the way, you said this is interfering in the process to have this hearing. The first time Congress had a hearing was in June 2020 over the Breonna Taylor episode. There was no concern about interfering. The concern was about the use of this kind of tactic to enter unnecessarily and jeopardize people's lives. Yep. Now suddenly that seems to be of no concern whatsoever. Can you account for that difference, Mr. Cummins?
The facts are very similar, although that was a drug investigation, and under the case law, they are allowed to go in faster because of the potential for destruction of evidence.
Yes, so in this case, we're talking about conduct that the law would say is malum prohibitum, not malum in se. In other words, what the reason they entered this residence and jeopardized this entire family, including Ms. Malinowski, who has no allegations against her, and shot this man dead, is because he didn't have the proper license for the business they say he was engaged in. And it's even disputed about whether he was engaged in that business.
Correct.
And in that case, Ms. Breonna Taylor's boyfriend was without any contradiction, engaging in illicit drug activity and receiving and deal. He was a drug dealer, and he was carrying it on in her place of residence. I can't account for the gross disparity, except that Americans hear a lot, and I hear a lot back about concern about a double standard of justice. Is there a double standard of justice here, Mr. Cummins, in those two episodes?
There appears to be, and that causes a loss of trust in government and in these agencies.
Mr. Kleckner, the only place I see reaction, besides a hearing like this exposing stuff, is that attorneys general across the nation have sued over the two rules, the business engaging in the business rule that's at issue here, I guess, really, and the pistol brace rule. Why is that the only recourse that people have state attorneys general file litigation?
I don't understand your question, Congressman. Are you saying that they should be?
My time's expired anyway. We're going to get anyone. I'm running out.
Well, we can give you a chance to, you want to rephrase the question?
Yeah, thank you, Mr. Chairman, if I can rephrase the question. Here's what I'm saying. Congress doesn't seem to be able to do anything to press back against this overreach. At least it hasn't, including under Republican leadership. The only thing that seems to be available to people for the government to do to provide recourse is I see a state attorneys general out filing lawsuits in great numbers, 21 states in one case, 24. Is that the only recourse that people can expect from their government in the response to these kinds of abuses?
It apparently is the only one they have, but it's not what they should expect. We should expect that the administrative agency is reined in a little bit here.
Thank you, Mr. Chairman.
We're trying. The chair recognizes gentlelady from...
Gentleman from New York is now recognized.
Thank you, Madam Speaker, and thank you to the distinguished gentlelady from Pennsylvania for yielding the time. I rise today with a warning for my colleagues on the other side of the aisle. You are setting a very dangerous precedent by trying to hold an attorney general who has provided all of the substance requested in a subpoena in contempt. And let's be very clear. This precedent that you are setting is one that your own former president and cabinet secretaries repeatedly violated in the last administration. In 2019, the former president famously said that he would defy all congressional subpoenas. And then he did just that during the impeachment inquiry. The State Department refused to turn over a single document. Under your precedent here, with Attorney General Merrick Garland, who has provided everything that you have asked for, except for the audio recording of an interview with President Biden and the special counsel, you are moving into dangerous territory. There is no legitimate legislative purpose to require the Attorney General of the Department of Justice to turn over the audio recording of an interview of which they have already turned over the transcript. Now, I hear my colleagues on the other side of the aisle use explanations such as demeanor evidence and character evidence. That's all well and good if you were considering whether or not to prosecute President Biden, but that's not the job of Congress. There's no legitimate legislative purpose in figuring out, quote, demeanor evidence as to whether or not President Biden, how he sounded when you have the information. And it is particularly galling that my colleagues on the other side of the aisle are going to try to hold the Attorney General in contempt for this narrow issue when he has substantially complied with the subpoena, when 5 of my Republican colleagues completely defied lawful congressional subpoenas last time, including the chairman of the Judiciary Committee. You are setting a dangerous precedent, and you, my friends on the other side of the aisle, ought to think twice, because what goes around comes around. And I yield back.
To call on Mr. Goldman next. So, Chair recognizes Mr. Goldman for 5 minutes.
Thank you, Mr. Chairman. It's been interesting listening to my colleagues on the other side of the aisle use phrases such as, quote, follow the science, unquote, and black letter law. Since science overwhelmingly has established that climate change is real and caused by human beings, especially oil and gas companies, I'm sure they will agree that if we are to follow the science, then we should stop denying climate change. Mr. Berry, do you agree with the Supreme Court's rationale and analysis in the Bruin decision?
So I'm not deeply familiar with it, but directionally, what I understand, it seems to construe the Second Amendment as a robust individual right.
And would you consider it to be a strict constructionist interpretation of the Second Amendment?
My impression is that it attempts to be a faithful exploration of the original public meaning of the Second Amendment.
The original public meaning. Okay. Just so everyone is aware, the Bruin decision interpreted the Second Amendment to only allow for gun regulation that existed at the time, or could have existed in 1789, when the Second Amendment was ratified. And of course, there were no machine guns, there were no bump stocks, the list goes on as to many technological advances that did not exist then. But it is the original meaning. Ms. Wiley, if we're going to talk about the original meaning of the actual black letter law, was there any evidence in 1964 of pervasive discrimination against white people?
No.
So it's fair to say this Title VII was, of course, not written because to right the wrongs of discrimination against white people in 1964.
That's correct.
So if one were to use the original meaning at the time that something was ratified or enacted, then discrimination against whites would not be included as a cognizable claim under Title VII. Is that right?
No, because it is true that Title VII prevents all forms of racial discrimination. The reality of why the law was drafted and passed in the first place was because there were no protections that recognized that Black people, that Native Americans, that Pacific Islanders, that other people of color who were not being protected by government from discrimination deserve to be protected by government from discrimination. Because what was happening for 100 years after the winning of a civil war to create true equal opportunity is that it was formally and constantly denied people because they were not white.
I agree with you.
So it didn't make it okay to discriminate against white people. It just made it clear you can't allow it against everyone
So
else.
it was, I'm making somewhat of a rhetorical point because I do agree with you that we should not have discrimination based on race. I just want to point out the hypocrisy and the convenience that folks on the other side of the aisle like to use in a cynical way black letter law and the original meaning of things when it's convenient, but not when it's not convenient. The fact of the matter is that 82% of business leaders consider diversity initiatives to be essential to their business strategy. 2% of business leaders say that these initiatives are not important. Diversity initiatives are credited with improving business performance, enhancing talent acquisition and retention, enhancing competitiveness, and fostering innovation. And 45% of business leaders said that the main reason they have diversity initiatives is to improve business performance. This is motivated by businesses, and it is demanded by consumers, just like ESD. And so if Republicans profess to be the party of deregulation and free markets, why won't you just let the market decide whether diversity and inclusion or ESD is something that the market wants? Why do you now want regulation? The fact of the matter is you want regulation because you want to go back to the white replacement theory and a time when, in 1964, we needed to pass a law to protect discrimination against people of color and underserved and marginalized groups, not against white people. And it is a shame that this entire Project 2025 includes attacks on immigrants and the expulsion of immigrants and the exclusion of immigrants who make up so much of our economy and are essential to so many aspects, both from agricultural workers to highly skilled workers with H-1B visas. And so I wish that we would have some consistency from the other side of the aisle in how we view diversity that as we approach with Project 2025, with immigration, and with our employment laws. And I yield back.
Chair now recognizes Mr. Mfume from Maryland.
Thank you very much, Mr.
Member is recognized. I thank the ranking member for the time and for his leadership and clarity on what is truly important and what is not. I rise today to celebrate the Republicans' National Appliance Protection Day, and this specific bill, the Refrigerator Freedom Act. That's right. My colleagues on the other side of the aisle are using their majority and our precious floor time to protect kitchen appliances. They are not trying to protect women's reproductive freedom. No, they're actually trying to take away a woman's freedom to control her own body. They are not trying to protect voting rights so that every eligible voter can vote. No, this week we actually will also be voting on a bill that is trying to make it more difficult for poor and rural Americans to vote. They are not trying to protect Americans' freedom to be who they want to be and marry whomever they want. No. Their Project 2025 platform intends to erase marriage equality for all Americans. And they are not trying to protect our children from their new leading cause of death in this country, guns. Nope. They are trying to protect every American's right to turn a semi-automatic weapon of war into an even deadlier automatic weapon of war. That's right. Instead of reproductive freedom, Republicans are focused on refrigerator freedom. In closing, I do want to give my friends on the other side of the aisle credit for one thing. They are certainly consistent. Just as they want to take our country back to the 1950s, where white Christian men were in complete control, they also want to take our appliance technology back to the 1950s as well. I yield back. Yields. Thank you, Mr. Chairman. I'm happy we're bringing up the appeal in this case because this committee has focused for a year and a half on a Fifth Circuit case, has brought before us as a witness the lawyer for that case twice to argue that the Biden administration had improperly censored social media companies. I'm surprised we haven't yet heard about the ultimate decision on appeal by the Supreme Court, which dismissed the case. So it's pretty fascinating to me that we don't have follow-up on the appeals of a case that we're so excited about the appellate process when the Supreme Court dismissed it. Mr. Fahey, I want to just touch upon a couple things you said before I move into the crux of my questioning. Am I right that I heard you say that it's unheard of to bring a fraud case without losses to individual victims?
I cannot think of a situation where that's occurred. I'm not saying it hasn't.
So you're saying that every books and records case has losses to victims?
I'm saying every fraud case that I was involved, either prosecuting or knowing about, usually had somebody that was harmed.
But this was a books and records charge, yes?
Well, I think it's based on a fraud case that somebody committed fraud on their books and records, yes.
So a fraud on the books and records?
Yeah, I think the allegation is they were incorrect or fraudulent entries in the books or the records, yes.
Right. And so you're saying that every single books and records fraudulent entry, which is a false entry, has lost to individual victims? Is that your testimony?
That's not at all my testimony. I said fraud cases are generally not prosecuted without victims. And
that's true. Murder cases are generally not prosecuted without victims too, but we're talking about books and records here.
Okay.
Are you familiar with the term fraud on the market?
No, not really.
Okay.
I mean,
you should look into that.
And
you should look into, let me give you another example of a fraud case that doesn't have a loss to an individual victim, which would be any insider trading case. So
other than they would have potential victims and other people harmed, this is a case where
go look up fraud on the market. There are no individual victims with losses, and yet those cases are charged
there's an overall
all of the time.
Harm in those cases.
You know, we're focused here on the weaponization of the government as usual, and I'm just struck by the fact that we have a Republican majority that is accusing other people of weaponizing government, when let's look at what this committee and this Republican majority has done. My colleague, Ms. Crockett, ably went through the separation of powers. Mr. Wu, were you aware that this committee held a hearing with Robert Costello as a witness, who was the former attorney of Michael Cohen?
Yes.
And that hearing was during the trial?
Yes.
Okay. So do you think that was an appropriate way of trying to elicit testimony to impeach a witness in a trial in a congressional hearing?
No, I think it interferes with the trial.
Now, interestingly, when he was here, I suggested that he go testify in the trial, and he did. That's the appropriate place for where he should be, right?
Exactly.
And Mr. Trump's attorney had an opportunity to cross-examine him, did he not?
Yes.
And Mr. Trump's attorney had, I believe, 3 days of cross-examination of Michael Cohen, did he not?
Yes, I think that's right.
And ultimately, the jury heard all of that, right? Yes. And all of the other evidence, and decided unanimously that he was guilty.
That's right.
Are you aware of the about 24 members of the House Republican Party writing an amicus brief to a district judge about the Hunter Biden case?
Yes.
So let me just get this straight. We have legislators, elected officials, trying to intervene in an ongoing criminal case. Is that what happened?
That's what it sounds like.
And they're proud of it, by the way. They are so excited and take credit for undermining Hunter Biden's plea agreement by interfering in that case. That is the misuse of official authority and weaponization of this committee, this body. And what Donald Trump has vowed to do is weaponize the Department of Justice to go after his political rivals, a revenge and retribution tour. And the notion that this committee is accusing Democrats of weaponizing the federal government when the President of the United States did not intervene in the prosecution of his own son. Give me a break. Why don't you focus on taking care of your own party and your own weaponization and stop projecting where it doesn't exist? And I yield back.
We appreciate the gentleman. The gentleman from North Carolina is recognized for 5 minutes.
So much to cover here from my friends on the other side of the aisle. First, I want to just address something that my colleague from Wisconsin said when he said that the Constitution lays out very clearly in Article 1 the powers of Congress. And I would just ask him or any of my colleagues on the other side, if you could point me to where in the Constitution it confers subpoena power on Congress. You won't be able to because it is something established by the Supreme Court that is derivative from Congress's power to legislate. So the Supreme Court has set forth exactly what a congressional subpoena is authorized to do. In a recent case, you may remember it, the Trump versus Mazars case, because Donald Trump sued his accountant to prevent them from providing documents to Congress with a subpoena. Oh, congressional authority. That's what we're worried about here. Well, the Supreme Court reiterated purpose in order for a congressional subpoena to be valid. So I asked in our when we debated this, what is the legitimate legislative purpose that any one of my colleagues on the other side of the can identify to justify a contempt finding here where they have the substance recording included in the transcript, and everything else requested in that subpoena was provided to them. Yes, they're insisting on getting the audio of that transcript that they have. Now, not surprisingly, in the Oversight Committee, which has no jurisdiction over this anyway, they offered nothing. But I did hear in the Judiciary Committee, my friend from North Carolina who is here, refer in a subsequent hearing to demeanor evidence as a legitimate purpose for this subpoena. Now, demeanor evidence is like a sophisticated legal speak that is very esoteric and only for trial lawyers, but really it is completely irrelevant to Congress's legislative role because we don't try cases. There's no trial here. There's no demeanor evidence. As much as you may want to prosecute Joe Biden, there is no congressional prosecution of Joe Biden, and his demeanor evidence is no legitimate basis for this subpoena. Now, you of course know, and I don't even think you'd argue, that there's a legitimate legislative purpose to use the audio recordings in a political ad to support your dear leader, Mr. Trump. So that clearly falls outside of the range. Of course, my friends on the other side of the aisle should refocus from demeanor evidence to basic concepts like due process or executive privilege. Because the President of the United States asserted executive privilege over this audio tape. You may not like it, you may not agree with it, but you have no authority to determine that that is not a correct assertion of the executive privilege. And you know who else doesn't have authority to determine that? The Attorney General, who you are trying to hold in contempt. Due process. You're going to fine someone $10,000 without notice or an opportunity to be heard? You're going to say, we're going to fine you because, and you have no opportunity to make a defense, and there is no neutral adjudicator? You can go to court all you want, and that's where you went, and that's where you belong. And that's why this resolution is such bogus. But I have a warning for you, my friends. You will reap what you sow. In June of 2019, then President Donald Trump said he would, quote, defy all congressional subpoenas. And that is exactly what he did. During the first impeachment investigation, every single executive branch agency defied a lawful subpoena from Congress.
Gentleman's time has expired. Members are reminded to address their remarks to the chair.
I yield the gentleman an additional 1 minute.
Gentleman's recognized.
The State Department was subpoenaed, the Defense Department, not a single document. So I look forward to whoever one day is the Republican Secretary of State or Secretary of Defense to be held in contempt and fined, inherent contempt and fined $10,000. There were more than a dozen witnesses who refused to comply with the subpoena. And I'm not even talking about the 5 House Republicans who defied subpoenas in the last Congress that were determined by a court to be lawful and who would also be subject to inherent contempt because, of course, if this case where the audio tape is not provided, then blowing off a subpoena is definitely contempt. So you ought to be careful about the precedent you're setting because it is going to hurt you and your dear leader far more than us. I yield back.
Gentleman yield.
Goldman from New York.
Wow. Mr. Regan, I don't want to spend too much time on this, but I would just like to clarify a few things for my colleague from Colorado. The Loper-Bright ruling, as you know, said that the courts should not defer to agency rulemaking if a statute is ambiguous, and instead the courts get to determine whether or not what the statute means. Is that your understanding as well?
Absolutely.
Okay, so that would not require any regulations to be reversed or overturned, correct?
Correct.
But I do want to talk about that case because it is an incredible power grab for the judiciary. And I want to go through a couple things with you. I'm going to take as one example a recent rule that the EPA implemented and finalized in March, the greenhouse gas emission standards for heavy-duty vehicles, which is, I think you've put it as a strongest national greenhouse gas standard for heavy-duty vehicles in history, and one that would have a significant impact on my district, one of the most densely populated districts in the country, where there's a lot of last-mile delivery facilities and operations that create a tremendous amount of greenhouse gases. Can you just very briefly, just for timing's sake, explain the process that the EPA goes through to, and what kind of expert analysis is used to final, and what kind of input is implemented to finalize a rule like this?
Well, you know, we have some of the world's best engineers and scientists who focus on these rules, and typically, especially in our Ann Arbor laboratory, or world-renowned laboratory, we invite in all of our stakeholders, all of the industry, the best manufacturers, the best engineers and scientists, and we go through simulations and really look at what would happen in the real world if we were to pursue some of these regulations. So we take our scientists, match them with the world's best scientists on the private sector side, and then we look at how we can build on the regulations that preceded the one that we're about to put in place. We also look at a cost-benefit analysis, and we look at penetration rates, we look at the market, and we best determine how can we put the best technology on the road that keeps this country globally competitive and also reduce the pollution that we're aiming for.
That is, thank you for the explanation. Quite a in-depth and detailed, lengthy process involving the world's greatest experts. In that room with the world's greatest experts and the EPA experts, are there any federal judges?
No.
So what the Supreme Court just did, am I correct, is say that the experts should not get any deference in how they implement the rulemaking process, but that the non-experts in the judiciary are the ones who get to do that. Is that your understanding?
Well, I'll be careful in commenting on this ruling, but what I can say is the experts that are in the room and myself and the CEOs that are in the room that are making these decisions, this new case seems to take that away from us and gives it to the court.
Exactly. A complete power grab that was led for many years, decades, by the Koch brothers, who have spent tens of millions of dollars in trying to overturn this Chevron doctrine in order to benefit their oil and gas and other industries that harm the environment. And you know what's interesting about this case, this Loper-Bright case, is that Clarence Thomas didn't recuse himself. He ruled on it. And yet Clarence Thomas took free private flights paid for by the Koch brothers, went to their events, raised money for them. This is all documented. And then after that, in 2020, Clarence Thomas just completely reversed his view of the Chevron doctrine. Funny, convenient. And yet he's ruling on this case. And what is going to happen is that this Trump Project 2025, just like Ms. Boebert said, is going to try to eliminate all environmental regulations. Donald Trump has offered to do that for the oil and gas company if their industry leaders can provide him with $1 billion to help in his campaign. But now that he has absolute immunity, if he becomes president, he can't get charged for that obvious criminal public corruption violation. And so he's going to try to implement Project 2025, eliminate the EPA, eliminate climate change from all regulations, eliminate the experts at the EPA and other agencies and put in his political lackeys, and then get to go to Clarence Thomas to determine whether or not what the executive agencies decided makes any sense. This is the destruction of our democracy. And I yield back.
The gentleman yields 3 minutes to the gentleman.
Thank you, Mr. Speaker, and I thank the ranking member. I rise today to address the Republicans' desperate attempt to, yet again, use the official business of the House of Representatives to do the partisan political bidding of Donald Trump. My colleagues on the other side of the aisle have spent most of this Congress wasting our time and taxpayer money on a bogus sham impeachment investigation of President Biden that yielded no evidence of wrongdoing, much less any high crime or misdemeanor. It was obvious that that phony effort was solely designed to provide election fodder for Trump in advance of November's election. And recently, the chairman of the committee overseeing that investigation even admitted as much. And now that President Biden has selflessly and patriotically passed the torch to Vice President Kamala Harris, my colleagues on the other side of the aisle are scrambling to help Donald Trump's electoral chances by using our time here today on a blatantly false resolution about Vice President Harris. The title of this resolution is, quote, strongly condemning the Biden administration and its border czar, Kamala Harris's failure to secure the United States border. There's one problem. There's no such thing as a border czar, nor was Vice President Harris ever named the border czar. The entire premise of this resolution is simply false. Not surprisingly, the resolution makes no mention of the border security bill that the Biden-Harris administration negotiated with Senate Republicans that would have comprehensively addressed the problems at the border. Nor does it say anything about Donald Trump's decision to sabotage and kill that bipartisan bill because it would have solved the problems that this resolution complains about. Now, why did he do that? Precisely because he wanted his minions in the House to introduce useless and deceptive resolutions like this one to help his campaign. And while Republicans continue to play politics with the border, the Biden-Harris administration did not stop trying to solve the problems facing the administration. They used what limited authority they have to control the border, and it's working. The resolution cites statistics from May of 2024 that there were 170,723 encounters at the border. But the resolution does not include numbers from the next month, June of 2024, which cut encounters by more than half to 83,536. And while my Republican colleagues continue to put politics over solutions, this administration and House Democrats will continue to put people over politics to address the issues facing the American people. I urge my colleagues to reject this false, inaccurate, and deceptive resolution. I yield back.
Mr. Goldman, the gentleman from New York, is recognized for questioning for 5 minutes.
Thank you, Mr. Chairman. I've got a lot to get through because we've got about 4 years to walk through. That chart, of course, mischaracterizes when Mr. Trump left office. But there's no question that the problems at our border have significantly increased over the last several years. We can debate the cause of that, and we have debated the cause of that. There's unquestionably a lot more climate migration. There's unquestionably a lot more authoritarianism in Central and South America that is leading to political persecution and to people wanting to flee. But there's a problem. And what happened is the administration began to address that problem as it was increasing. But Republican attorneys general all around the country filed lawsuit after lawsuit after lawsuit to stop administrative action. So in response to that, the Biden-Harris administration went to Congress to say, let's work on bipartisan legislation to try to solve our border crisis. And Senator Lankford, the second most conservative Republican in the Senate, negotiated for months with an independent and a Democrat and with the administration to come to some sort of bipartisan resolution, which they did miraculously because this has notoriously been a very difficult issue. Now, that deal was the most conservative border security immigration bill that's ever been agreed to by any Democratic administration. It had a number of different provisions, but I think most importantly would have dramatically streamlined the asylum process. And let me just say something about the asylum process, because there's a lot of talk about legal immigration and illegal immigration. Asylum is legal immigration. It is not illegal immigration. It is part of our laws that you may seek asylum under certain circumstances. The problem we have at the border and the problem we have with our asylum process is that only 20 to 25% of people who apply for asylum ultimately get asylum. But it takes 7 to 10 years for that process to play out. This border security bill would have dramatically shortened the asylum process such that it would be over in 6 months. And the incentive for someone who knows that they do not qualify for asylum to come across the border would be eliminated. And many of those 75 to 80% of people who are not eligible for asylum would not come here and would not be granted work permits. The other thing it does is it would increase visas, because we do have a work shortage. We have a job shortage for agriculture, for construction, for restaurant workers, hotel workers, home care, nurses, doctors, scientists. This is all what I hear in my district. We need to increase those quotas. That bill would have done it. We need, as Mr. Heike said, to increase personnel at the border to deal with the problems so that we can address the women who are being raped, so we can address the cartels that are fueled by American-made guns. We need more personnel. We need more resources. This bill would have done it. But what happened? Donald Trump killed the deal. He's open about it. And you know why he killed the deal that would have dramatically solved our problems at the border? Because he cares more about his own election than he does about the problems facing the American people. And he wanted chaos at the border so that he could run on it. And when you watch him at the debate, he answers every single question. It doesn't matter what the topic is, by going back to immigration. That's what he wants to do. I want to put up, finally, this last quote here from James Lankford, who was the author of this bill and was understandably very frustrated that it did not pass. It is very, very clear that the Republicans do not want to solve the problem at the border. And so what has happened since Donald Trump killed this bill that would have dramatically addressed the solutions at the border? President Biden and Vice President Harris have had no choice but to implement executive actions to streamline this process so that people coming in have to come in through ports of entry, so that those 73,000 people who are stopped at the border, they're not getting in, they're stopped at the border, have to go through the points of entry so that we can vet them and check them for their criminal history. And that has reduced border crossings to a level not seen since 2019. More than 55%. But that's not the solution. The solution is legislation, and the Republicans will not meet in the middle. I yield back.
The gentleman yields. My. So here we are.
Mr. Chairman, I yield 3 minutes to the gentleman from New York, Mr. Goldman.
The gentleman is recognized.
Thank you very much, Mr. Speaker, and thank you to the ranking member. I rise today to discuss the next installment of Republican hypocrisy, the 118th Congress. This one relates to anti-Semitism. My Republican colleagues have spent months haranguing university presidents for failing to protect Jewish students on college campuses. And on this, I agree. Many university presidents have failed to show the appropriate moral clarity and leadership. But let me ask my colleagues on the other side of the aisle, does the removal of a university president actually change the facts on the ground? Does it make Jewish students safer? The answer is unequivocally no, certainly not in the near term. I have spoken to Jewish students all around the country, and they remain scared and afraid as anti-Semitic encampments and protests have grown more threatening and even violent. And despite all their lip service about combating anti-Semitism, this Republican bill makes it significantly more difficult for universities to keep Jewish students safe. Under the guise of ending wokeness on college campuses, this bill would strip universities of their ability to enforce reasonable restrictions on campus protests. It limits time, place, and manner restrictions and allows for no-notice, spontaneous protests, including anywhere on campus, such as Hillel's. That's right. The bill makes it easier for agitators and others to come on college campuses and engage in anti-Semitic protests or encampments. Once again, all talk, no action from my Republican colleagues. The most effective way for the federal government to combat anti-Semitism on campus is through the enforcement of the Title VI anti-discrimination law by the Office of Civil Rights in the Department of Education. which requires universities to remedy any violations that make Jewish students or any other students unable to safely and securely get the education that they deserve. Since October 7th, OCR has opened more than 150 investigations into campus anti-Semitism, but they don't have anywhere near the resources to fully pursue those investigations. Now, never mind that Donald Trump's Project 2025 wants to eliminate the Department of Education altogether, including the Office of Civil Rights. But if Republicans truly cared, as they say, about Jewish students, they would support my Showing Up for Students Act, which would increase funding for OCR so that we can actually combat anti-Semitism on the ground at universities around the country. Yet not a single Republican has co-sponsored this bill. Not one. Instead, in the last budget,
Give the gentleman an additional minute.
Gentleman is recognized.
Instead, in the last budget, Republicans insisted on cutting funding for OCR, further hampering OCR's ability to fight anti-Semitism. So I once again ask of my colleagues on the other side of the aisle, stop using anti-Semitism as a political weapon and join us to actually solve the problem. If you care about anti-Semitism on college campuses, you must oppose H.R. 3724 and instead join my Showing Up for Students Act so Congress can be part of the solution, not the problem. I yield back. The third installment of the Defending America from the CCP's Political Warfare. After the chairman's impeachment investigation revealed zero connections between President Biden and Chinese businesses, he nonetheless shockingly views the nakedly partisan political sham impeachment as a success. Why? Because President Biden dropped out of the presidential race. Now, that is a blatant admission that this committee was used improperly for partisan purposes. But that failure has not stopped the chairman from continuing down this road. Now that Governor Tim Walz is on the ticket, Chairman Comer has quickly pivoted to focus this committee's resource on Governor Walz's time teaching English in China, insinuating that somehow that is a problem. What we really need to be focusing on as it relates to CCP's political warfare is defending this committee from that political warfare. Remember, we have two witnesses who were the star witnesses of the impeachment investigation. The first, Gal Luft, turned out to be an indicted, unregistered foreign agent of the Chinese government. Among the allegations in Gal Luft's indictment was that he, at the behest of Chinese entities, recruited and paid an unnamed advisor to then-President-elect Donald Trump to adopt pro-Chinese positions. And even though he also was charged with making false statements to the FBI, Chairman Comer bragged and said Gal Luft is a very credible witness on Biden family corruption. That wasn't all the political warfare that we experienced during this impeachment investigation. Alexander Smirnov is a Russian indicted as a source for the FBI who literally met with Russian officials to peddle lies to the FBI. You know what those lies were? They were the same allegations that the chairman made against Joe Biden in this committee, Russian propaganda. Now, this is not, unfortunately, the chairman's only connections to China. Just months after our last hearing on the CCP political influence, a news report alleged that while he was the agricultural commissioner and candidate for governor of Kentucky, the chairman was involved in a failed Chinese hemp deal that would have benefited a campaign donor's company. This deal not only failed,
But it turned out that Chairman Comer accidentally imported illegal marijuana instead of legal hemp. So maybe we should be investigating Chairman Comer's ties to the CCP. But there's more political warfare from China that this committee should be investigating. Let's start with former President Trump, who acknowledged that he had a Chinese bank account that he used at least from 2013 to 2015, and his own lawyer said that it remained open throughout his presidency. Or let's talk about Ivanka Trump's fast-track trademarks that she received in 2 months, 18 of them, even though it usually takes 18 months. Coincidentally, I'm sure, it happened right after Donald Trump intervened to save a sanctioned Chinese electronics maker, ZTE. And China's biggest controlled bank, state-controlled bank, rented 3 floors in Trump Tower while Donald Trump was president, netting him $7 million. Now, the chairman won't investigate these incidents because the goal is not really here to combat political warfare or foreign influence in our politics. It's simply to use this committee to baselessly smear Democratic presidential and vice presidential candidates. But the American people know which presidential candidate is a danger to our national security. And it is the one who accepts millions of dollars from foreign governments while he is president. And it is the one who sucks up to dictators and despots all around the world who cannot even say that the democratic country of Ukraine should win the war against Vladimir Putin. So this, unfortunately, while an important topic, is a waste of time as we sit 6 weeks before the election. And as usual, we could have been doing so many better things with our time. I yield back.
Chair recognizes Mr. Biggs from Arizona.
Thank you, Mr. Chairman. Thank you.
Pursuant to notice, I now call up H.R. 5729. The bill was circulated in advance and printed copies are available. The clerk shall designate the bill.
H.R. 5729, offered by Mr. Pfluger, to prohibit the use of federal funds to establish a Homeland Intelligence experts group and for other purposes.
Without objection, the first reading of the bill is dispensed with and it's considered read and open to amendment at any point. I now recognize Mr. Pfluger for the purpose of offering an amendment in the nature of the substitute. The clerk will report the amendment in the nature of the substitute.
An amendment in the nature of a substitute to H.R. 5729, offered by Mr. Pfluger.
Without objection, the reading is dispensed with and the amendment in the nature of the substitute should be considered base text for the purpose of the further amendment. The gentleman from Texas is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman, for bringing this bill that would prohibit the use of federal funds to establish a Homeland Intelligence experts group, or any similar group for that matter. In September of last year, DHS established a Homeland Intelligence expert group. This group was allegedly made up of members to advise the Office of Intelligence and Analysis and assist with decision-making and provide outside perspectives on intelligence and counterterrorism. 2 of the so-called experts in this group are John Brennan and James Clapper, who both signed a discredited public statement on October 19, 2020, that incorrectly implied reports of Hunter Biden's political influence peddling were the product of Russian disinformation. The statement was used by multiple media organizations and social media companies to downplay and suppress reports before the 2020 presidential election. Further troubling is the fact that the experts group also included a former Justice Department official, Tashina Gahar, who was extensively involved in the FBI's probe into baseless allegations that President Trump colluded with Russia in the 2016 election. For a group that is supposed to be objective and nonpartisan, DHS stacked this group with individuals who have abused their credentials and prior roles within the federal government to seemingly advance partisan or personal agendas. On May 2nd, DHS agreed that the Homeland Security Intelligence Group's expert group would be wound down following litigation that raised serious concerns that members of the group did not demonstrate objectivity. While this was a step in the right direction, DHS later formed a seemingly rebranded Homeland Intelligence Advisory Board to build upon, quote, build upon the experts group. On June 25th, 2024, Republican members of the committee sent a letter to Secretary Mayorkas requesting documents and information regarding this advisory board. And other than a boilerplate letter response, these requests remain, to this day, outstanding. It's unsurprising that we've been stonewalled by DHS and our requests have gone unanswered, but this is a consistent theme. My common sense legislation simply prohibits the creation of the group or the formation of any group, program, initiative, or any other similar effort that's equivalent to the group within DHS, no matter the administration, that could be used to potentially support political agendas or messaging while being guised as an expert or advisory group. And I'd also add that the House Permanent Select Committee on Intelligence has included a similar provision in the Intelligence Authorization Act that prohibits federal funds from being obligated or expended to support the expert group or any successor group as well. That similar provision was passed out of the committee. It's imperative that DHS works to address the catastrophic border crisis in which over 10 million immigrants have crossed the border illegally, including almost 400 known or suspected terrorists, or INA's shortcomings to live up to the original purpose that DHS was supposed to have for them. As we sit through these briefs, these threat briefs together, and we hear information, and we go into a SCIF, and as a user of intelligence for over 25 years, who struck targets in enemy territory, it is critical that we get nonpartisan, unbiased, non-politicized, factual intelligence. There is no place in any administration for the politicization of intelligence. The American public is putting their trust in us to go into that SCIF and perform the correct duties to analyze the intelligence that we get. This is common sense, and it's actually, our country depends on it. The safety, the security of our country and every single citizen depends on doing just that. We have to stop any sort of effort to politicize. And if we all believe in that, this is going to be an easy bill to support. With that, Mr. Chairman, I yield back.
Gentleman yields. Does anyone wish to speak on the amendment?
Yes, Mr. Chairman.
Mr. Goldman, you're recognized.
Thank you, Mr. Chairman. I agree with my colleague from Texas. There needs to be nonpartisan, apolitical intelligence and expertise that informs all of our executive branch agencies. That's a big part of the reason why Schedule F of Project 2025 is so dangerous, because it would literally remove all nonpartisan experts from the federal government and allow for anyone implementing it to install political lackeys with political viewpoints. The problem with this bill is several-fold. First of all, this group does not exist anymore. So then the question is, why does this bill prohibit it? And that gets to the next point, which it clearly is not intended to prohibit this specific intelligent experts group. It is the grossly generalized language of any similar effort that this bill would also preclude. And I at least appreciate that my colleague from Texas was open about the reason why he is putting forward a bill that would make it more difficult for the Department of Homeland Security to gather expert advice in order to do their jobs. And we've had a lot of testimony in this committee, including from some of these outside groups who work with CISA to ensure that our elections are secure, that the DHS relies very heavily on outside experts. So you want to get to the rub of this, which is that you don't like the letter that 51 former intelligence officials signed in October of 2020, which you misquoted. It did not say that the Hunter Biden laptop or the release of the information about it was Russian disinformation. It said that based on all of their expertise, it had the hallmarks of Russian disinformation. And there are lots of very good reasons for that, that I know you choose to ignore. Let's just dig into it for a minute, because who was the source of, it wasn't a laptop, it was actually a hard drive. Who was the source of the hard drive? The source of the hard drive was Rudy Giuliani. And now we know, after there's been declassified information, that Rudy Giuliani was cavorting with known Russian intelligence agents for over a year leading up to that October surprise. So the notion that an intelligence expert, such as the former director of the CIA or the former director of the Office of National Intelligence, would view a selective release by someone cavorting with Russian assets, Russian intelligence agents, to be a hallmark of Russian intelligence is accurate. It's 100% accurate. You just don't like what it said, and you don't like that neutral, objective intelligence officials would read the cavorting and association of Rudy Giuliani with Russian intelligence agents to be an obvious and objective concern about Russian interference in our election, just like they, of course, did in 2016. And so let's go back to this. The other woman, I'm not familiar with her, but you said something about the Russian investigation.
Will the gentleman
Are you,
yield? 10 seconds.
Sure.
Mr. Chairman, it's nice that we can have fun. I mean, I do. It is good to have.
Do you have a yielding for a question, or what's your?
But if I wanted to ask you about the definition of "is," as we go back to the hallmarks of Russian disinformation.
All right, I'll reclaim my time. So,
the gentleman reclaims.
The interesting thing is that the entire intelligence community has definitively assessed that Russia interfered in the 2016 election. Are you now saying, Mr. Pfluger, that anyone who has ever signed on to an intelligence determination or assessment that says that Russia interfered in the 2016 election cannot provide any information or expertise to anyone in the federal government because they show signs of political bias? And I'm happy to yield to you to answer that question.
Yeah, thank you. And I know that this is a personal issue for you here.
No, it's not personal to me.
It's
personal to
if
the
you're
United
reclaiming,
States.
if you're reclaiming, reclaim.
No, go ahead.
With previous dealings with this issue. But I think you're also in agreement that we shouldn't have politicized intelligence. I just heard you say that for a couple of minutes.
I am.
So
I'll reclaim my time. The problem is you are parroting misinformation and incorrect information to impugn very dignified and respected former members of the intelligence community who have given their careers to this country to protect our country with intelligence, that they carry a tremendous amount of expertise.
So the gentleman's time has expired, and I'm comfortable if someone else wants to yield to him, but as I said at the beginning of committee today, I'm going to stick to the 5-minute rule because it's a long 21 bill or 20 bill day. So does anyone else wish to comment on the bill? Mr. Carter, you're recognized.
I yield my time, Mr. Goldman.
Mr. Golden, you're recognized.
Oh, thank you. I'll finish up briefly because it's pretty remarkable that this bill is being put forward to prohibit any funding for any outside expertise from former intelligence officials or anyone with expertise to the Department of Homeland Security, which we all know that the department relies heavily upon because of your subjective viewpoint that an assessment that something carries the hallmarks of a Russian intelligence operation is somehow a politicized viewpoint and therefore undermines the credibility of anyone who had signed that letter to be able to give nonpartisan or apolitical intelligence. You are hamstringing the department from trying to receive expert information from those who are public servants and who are experts. And you're basing it on your own political views, not their political views, because you don't like things that they may have said based on their objective experience. And so I just want to note for the record, and I hope this does go into the legislative history, that because this term, similar effort, is so overly vague as to be undefined, that this bill shall not apply to anything other than the Homeland Intelligence Experts Group, and that whatever successor or future group that the Department of Homeland Security would like to convene in order for them to do their jobs better is permitted and should be funded by the Department of Homeland Security, because this is unconstitutionally vague otherwise. And so I want the legislative record to note that this must be interpreted as solely affecting the Homeland Intelligence Experts Group. And I yield back to Mr. Carter. Thank you.
Gentleman yields to Mr. Carter. Gentleman yields.
Mr. Chairman.
Does anyone else wish to?
Mr. Chairman.
Ms. Green, you're recognized.
Yes, I'd like to enter for the record 2 letters that the committee sent to Secretary Mayorkas about this issue. So I'd like to enter both of these into the record.
So ordered.
Also, I'd like to remind everyone that the Russia hoax started with Christopher Steele writing a dossier. No, I do not yield time to you. Writing a dossier.
You know you're wrong, though.
Writing
Say this over and over.
Mr. Goldman, you do not have the floor.
Written by Christopher Steele, paid for by Hillary Clinton's campaign and others. This was purely politics to smear Donald Trump in the 2016 election. It was a complete and total lie, propagated by Democrats and the media. Smeared President Trump, leading to the Russia hoax, leading to this lie, and the American people know it. Here's the real issue. People like James Clapper and John Brennan, they should not have their security clearances. They should be revoked and taken away because they no longer work for the government. They go on television and lie about things like the Hunter Biden laptop. They go on television and talk about a letter they've signed with other intelligence community experts lying about the Hunter Biden laptop in order to make the American people believe something that isn't true. They use their title as intelligence community experts, and they use that heavy weight of that title to tell lies to the American people, to persuade people during a presidential election. You want to know where the contents of that laptop came from? Came directly from Hunter Biden, because that was his laptop. And all of the information on that laptop belonged to Hunter Biden. The liars were the 51 intelligence community experts, so-called experts, that signed their name to a lie in order to persuade the American people of such a lie. That's why those people honestly should not have their security clearances anymore. They shouldn't. And, perhaps that's a bill we should consider, Mr. Chairman. I support this bill, and I yield to my friend, Mr. Pfluger.
Mr. Chairman?
Thank you to my colleague. And just as a point, that laptop has now been entered as evidence as a federal crime by the Justice Department. So let's just get the facts on the table here.
Will you yield?
No, I won't. But and I think it's also a point, Mr. Chairman, to direct our comments to the chair as a matter of our decorum here in the committee room. But this is important. This is important that we get to the heart of the matter. And every American deserves to hear the truth, the facts. And when we have politicized people who, for the purpose and using their security clearances to politically motivate, suppress, or censor information, then there's questions. And that's what this bill addresses. It addresses that very thing. It gets to the heart of our homeland security. There's no room for politicization of intel, period. And that's all it is. It sounds like that you support that. So I look forward to seeing you vote in favor of this. I'll yield back to my friend from Georgia.
Thank you. Mr. Chairman, I yield the remainder of my time.
The gentlelady yields. I recognize Mr. I did hear a female voice. Mr. Ramirez, you're recognized for 5 minutes.
Thank you, Mr. Chairman. My colleague in front of me started with saying we should not be politicizing our time here. But as I'm hearing debate on this particular bill, it is all about politics. I strongly oppose H.R. 5729 because it is a MAGA political stunt that folks would have long-lasting damaging effects on Homeland Security. The bill's language belies what its actual purpose is. You see, the bill, it says that it would defund Homeland Intelligence Experts Group, but as my colleague to my right here said, it no longer exists. But this bill does go far beyond just that. It actually prohibits any federal funding for the establishment of an equivalent group, any program initiative, or any similar effort. And it goes as far as attempting to tie future Congress's hands by prohibiting the authorization of any activities at DHS that are equivalent to activities of the experts group. But see, looking at the legislation, nowhere in the legislation is equivalent group or similar effort defined, nowhere. So this vague, overbroad legislation would prohibit DHS from soliciting and receiving diverse perspectives on Homeland Security intelligence from outside intelligence groups, from civil rights and liberty organizations, from local law enforcement agencies, from state and local governments, from private industry, I can go on. In fact, H.R. 5729 would prevent the very people and the organizations that DHS aims to protect from weighing in on DHS intelligence activities. Mr. Chairman, I don't know about you, but I want DHS to have the ability to actually engage with people and organizations outside the federal government without regard to politics, so that the people and the organizations DHS serves can actually have a voice on what DHS is doing. This bill, it's the opposite. For that reason, I oppose H.R. 5729, and I give the remaining of my time, I yield it back to Mr. Goldman.
Thank you very much, and fully agree with everything you just said. I'm just going to take a quick opportunity to clarify some blatantly false statements from my colleagues, which not only were once again reiterated in this committee room, but have been pervasive and persistent for many years now. First of all, let's talk about evidence, which my colleague from Texas brought up. That is correct. The laptop belonging to Hunter Biden was admitted into evidence in a trial. That is a different piece of technology than the one that was provided to the New York Post. And if you don't believe me, you can ask the former New York Post writer who testified before the Weaponization Subcommittee, who acknowledged that she received a hard drive, not the laptop, a hard drive from Rudy Giuliani. And it doesn't take a computer expert to understand that hard drives can be manipulated. So if your point is to say that because the Hunter Biden laptop was introduced into evidence in a trial, that therefore whatever Rudy Giuliani had was legitimate, you're sorely mistaken and completely wrong. I also would just like to briefly address one thing, because it's impossible to address everything that my colleague from Georgia said. The Russia investigation very clearly started from a tip from an Australian diplomat to the FBI about a conversation that he had with someone who was involved in Donald Trump's campaign. You like to lump in the Christopher Steele dossier as if that had anything to do with the origination of the actual Russia election interference investigation. It did not. It did have to do with subsequent FISA warrants, and that has been the subject of an intelligence committee, but that had absolutely nothing to do with the investigation that led Special Counsel Mueller to conclude that Russia interfered in the 2016 election, the Trump campaign knew it, and the Trump campaign welcomed that interference and used it for its purpose. So the Steele dossier has nothing to do with that investigation. Let's be very clear about that. I yield back.
Mr. Chair.
That's
Thank you. And I just want to set the record straight because there's been some misinformation here. The Hunter Biden laptop, the reason somebody had it was because he failed to pick it up. And there was a copy of the hard drive of the laptop was given to the New York Post. That story was published. And at the time, a senior Biden administration or Biden campaign official by the name of Anthony Blinken, he called an individual by the name of Michael Morrell, who was a former deputy director of the CIA. He asked to help draft a letter that urged the intelligence community to be vigilant about Russian disinformation during the 2020 election. Now, they signed it, and they signed it with saying that this had all the earmarks or hallmarks of hallmarks, really should have said hallmarks, of Russian disinformation. This story about Hunter Biden and his laptop. All the while, they knew that the information was actually true. Because, I'm not going to yield, okay? Because they knew that they had a copy of of Biden's laptop. The New York Post had already written about it, and it was done 2 days prior to a presidential debate in order to give President Biden cover that he took out and said 51 intelligence officers said that this is misinformation.
Will you yield for a question?
No, I won't.
Just for a question.
No, I'm not. Okay, so don't ask again, okay? That this is misinformation, all right? So the only people that really interfered in our election, because later, when asked, a poll was taken about, hey, had you known that the Hunter Biden laptop information was real, would you have changed your vote? A good number, enough to overturn that election, said they would. So the only people that really interfered in our election were the supposedly, trusted experts of the intelligence community that lied to the American people. Not directly, very, very smart. Like I said, had all the hallmarks of. And that was used by the technology companies like Twitter at the time, Facebook, to subvert and basically destroy that story, which was true all along. And not one thing that the New York Post has ever written about what was in that laptop has ever been disputed as being false. Not one thing. After now we know that we have the Hunter Biden laptop. So good trying to change history, okay? But history has a way of coming back and biting you, just like it's doing right now. Because that's exactly what happened, and that's the truth. And by the way, at the end, I still have some time, great, okay. At the end, the only party, the only people that actually paid Russians to lie and put false information into the Steele dossier was the Clinton campaign and the DNC, who by the way, tried to wash that payment through a legal firm, and then they were fined by the FEC for doing that to the tune of about $500,000. All right? So the only people trying to really fool the American people, are sitting on that side of the aisle right now. Thank you.
Will you yield now?
Will the gentleman yield?
I'll yield my remaining time to you.
Thank you. I'd like to enter for the record an article dated March 17th, 2022, 2 years after the 2020 election, where 51 intelligence community so-called experts lied to the American people, saying the Hunter Biden laptop wasn't real. The New York Times belatedly admits the emails on Hunter Biden's abandoned laptop are real and newsworthy. That would have been great information for the American people in the election of 2020. Mr. Chair, I'd also like to introduce for the record another article dated March 30th, 2022, after 51 intelligence community experts lied to the American people in 2020. This one is titled, Washington Post Joins New York Times in Finally Admitting Emails from Hunter Biden Laptop Are Real. I'd like to enter those for the record, Mr. Chair. Thank you. I yield back.
Without objection, both will be entered into the record. would like to remind all members to please direct their comments to the chair and not to other members here. I will be happy to receive those comments. Do any other members wish to speak? Ms. Clark, you are recognized.
Thank you, Mr. Chairman. I yield to the gentleman from New York, Mr. Goldman.
Thank you to my colleague from my next door neighbor in New York. I'm not going to belabor this. It's been belabored for 8 years. I will point out one fundamental flaw in my friend from Florida's recitation of what transpired. These were 51 former officials who did not have access to the FBI's evidence files and could not have had any. Do you need to, can you just listen? And who could not have had access and so would not have known whether or not there was a real laptop or whether it was compared. And that's why the fact is that when they said these are hallmarks of Russian intelligence operation, they were speaking based on their expertise of being longtime public servants, intelligence officials who have dealt directly with Russian intelligence and their efforts not only to interfere in the 2016 election, but going back decades. So I know my colleagues like to throw around the idea that they lied. They had no information to the contrary because only the FBI had the laptop in its custody and nobody else had the laptop. And as many people acknowledge, I'm sure even my colleagues on the other side of the aisle would acknowledge, hard drives can be tampered with. So the fact that there was information on the laptop does not mean that that information remains untampered on a hard drive. So let's just get this straight, because ultimately what this bill is about is a retributive effort by the Republicans to punish intelligence experts who don't share their view of politics and policy, but who used their expert judgment in an objective way with the necessary and proper qualifiers, and in no way, shape, or form lied under any definition of that word, except for the completely perverse definition that I guess my colleague from Georgia seems to have. But let's call a spade here, because you are essentially trying to make sure that the Department of Homeland Security does not have access to expert information in order to keep our homeland safe. And you're doing that because of a misunderstanding and misrepresentation about what you would like to have as revisionist history, that some of those experts actually, opinions that those experts actually made. And it is truly a shame that my colleagues on the other side of the aisle are falling prey to this really ugly and political discourse that is having a dramatic and would have a dramatic impact on the Department of Homeland Security actually keeping our homeland safe. Ms. Clark, I'll yield back unless.
Mr. Chairman, I yield back.
The chair recognizes the gentleman from Arizona.
Thank you, Mr. Chairman. I think it's interesting that my colleague from New York, Mr. Goldman, just argued that they had no evidence to the contrary because the FBI had the laptop. If they had no evidence, Mr. Chairman, then why did they feel it necessary to release this letter without having all the evidence? Normally, that's pretty common when you're investigating something. And I think Mr. Jimenez, my colleague from Florida, pointed out exactly why they did it, because they were scared to death that this evidence that had been released, regardless of who it was from, was true. And if it was true and the American people found out about Hunter Biden and everything that he was up to, would have voted differently. And polls showed that post-election. All
You
right?
voted differently for Hunter Biden?
Sir, I haven't yielded my time. Thank you. If you could respect that, I respected while you were talking. My colleague talks about the fact that he doesn't like, my colleague from New York talks about the fact that he doesn't like, or that we don't like, that this information came from Rudy Giuliani. But what he's not telling you is what he doesn't like is that now after we're close to 4 years removed from this, everybody knows that the Hunter Biden laptop is in fact true. He can make every argument in the world, but we all know it's true. And here's the thing. When I hear some of my colleagues, Mr. Chairman, talk about, oh, we don't want Homeland Security working with experts or outside sources, this bill is not going to stop that. Law enforcement and DHS will continue to use experts and outside sources. What this bill does is stop DHS and the American people from funding an experts group. So I want to make that really clear. We're going to continue to use experts. Law enforcement will continue to use experts, sources, people who are giving them information. It's not going to stop that. Thank you, Mr. Chairman.
Will the gentleman yield?
I yield.
Gentleman yields back. Any other member wish to be recognized?
Mr. Chairman.
Ranking member is recognized.
I actually would like to get back to the bill. The Hunter Biden thing kind of distracts from what I think is the original intent. In reading this legislation, I want to figure out the purpose. The purpose is, as Mr. Crane referenced, it talks about specific information advisory committee, expert committees. I'm convinced that when you prohibit an agency from having that kind of access to information, you make us vulnerable. And I would hope the gentleman in making this bill will want to keep us safe. I think any secretary should have access to all the experts available on any given subject. And I would encourage this committee to prohibit that makes us vulnerable as a country, but also it limits whoever the secretary is from doing his or her job. My understanding is that the Homeland Intelligence Advisory Board is basically a forum for DHS to get input from a variety of communities, including intelligence experts, Homeland Security experts, private and civil liberties folk, and all this. I don't see us saying you don't need to talk to these kind of people because their mission is to keep us safe from foreign and domestic challenges. And I don't know how you can do it without talking to people. So I'm inclined to think that we want the federal government to hear all the diverse views possible and then make a rational decision on the information collected. So from my perspective, I'll be voting no on the bill. I yield back.
Gentleman yields back. Chair recognizes the gentleman from Texas. Gentleman's recognized.
Thank you, Mr. Chair. I think the assertion that there's somehow a personal motivation to make our country less secure is ludicrous. Like, that's absolutely ludicrous. And I know some in this room are new to intelligence and going into the SCIF and receiving these briefs. But we're not talking about diverse views, we're talking about facts. That's all that matters, are the facts. I'd actually like to work, my colleague from New York mentioned that the 51 folks that signed this letter had no access to the FBI files prior to signing this letter. That they had no access to the facts is what I heard him say, that they could not have known, and I quote, they could not have known. I think that's exactly the reason that we're concerned. Because they could not have known. And actually, I would like to work with my colleague from New York on something. If we're so sure that this group of experts was right, why don't we ask them to come take a polygraph on their letter? And let's just set the record straight. for once and all. Let's ask them to take a polygraph about that letter, because that is actually a requirement when you have access to classified information. You submit yourself willingly with a non-disclosure agreement that says you won't talk about classified information, and that you submit yourself willingly to a polygraph. Anybody who's had access to classified information in any other agency in this federal government has signed that letter. I've signed it. Everybody else has signed it. Let's ask that group of 51 people, will you work with me on that? Will you ask them to come take a polygraph on this issue? I yield.
Will the
Thank you. Would
gentleman
you yield?
yield?
Thank you. Just to follow up on that.
I just wanted, will you work with me to ask them to do a polygraph?
You know they've all testified under oath to the
That's not the question I'm asking.
Judiciary Committee.
That's not the question.
Mr. Chairman,
Okay.
I reclaim my
Point of
time.
order, claim, the gentleman from Texas has
Pull this thing
reclaimed his
back
time.
on, just pull this thing back on the rails. Mr. Pfluger, are you done?
Would the gentleman yield?
The gentleman from Texas controls the time.
Mr. Goldman, I'll yield to you, and then I'll reclaim it, so use it wisely, please.
Goldman, you're recognized.
Thank you. I just want to be very clear. They made an expert assessment based on their training and experience and the facts that they knew. They did not say this information is false. They said it had the hallmarks of Russian disinformation campaign. So I don't know, I'm happy for them to come into polygraph. I don't really care. I'm sure they would say the same thing, which is not that they said, we are right, we are wrong. It was flagging an issue in the election after Russia had done the exact same thing.
Mr. Chairman.
And I yield back.
Thank you, Mr. Goldman. Ms. Green?
Thank you. I'd like to tell the committee there's important information to know about this advisory board, DHS advisory board. Members on the advisory board are highly political. Frances Taylor, a former Obama administration, made at least 650 political contributions, totaling over $32,000, all to the Democrat Party or Democrat candidates for office. Asha George, Rajesh Day, Karen Wagner, Elisa Massimo, they also made a combined total of 179 political contributions, totaling $60,000 exclusively to Democrat candidates for political office. I definitely support this bill. No federal funds should establish a Homeland Intelligence expert group filled with people that are highly political. So much so, they're not just political in their voting record, which is private. They're political with their funds. And they do it openly by supporting the Democrat Party and Democrat candidates. I don't think this is good. We've seen it with the intelligence community signing their name to a lie, and they knew it was a lie. 51 intelligence officials lied about the Hunter Biden laptop, and we saw the Democrats lie about the Russia hoax. Thank you. I yield back.
Yield back to the gentleman from Texas.
Mr. Chairman.
Latrell, will you yield for 5 seconds to me? 10 seconds, whatever you have left.
Yes, sir, Mr. Jimenez.
Thank you. The point is that the origin of that letter is purely political. It came from the Biden campaign. Mr. Blinken was working for the Biden campaign, and he asked a senior intelligence official to help him draft it and have people sign it. And since they didn't know if it was true or not, they should have never signed it because they didn't know if it was true or not. That came out of your own mouth, all right? So it was purely political act, and that's what we're trying to stop right now. Thank you.
We're actually trying to stop interference in our elections. That's what we're trying to stop.
Come on, hey, Dan.
Does the gentleman yield back?
Yes, sir, Mr. Chairman, I yield back.
Gentleman yields back. Does any other member wish to be recognized to speak on the amendment? Gentleman is recognized.
I just want to join the ranking member in sort of getting back to the text of this bill. This would be a complete ban on funding any type of advisory group. And so, Mr. Pfluger, do you believe that it's important for executive level officials to be able to engage and get the insights of state and local governments and private industry? And so I would yield to you because I think that's critically important.
No, thank you for that.
If you think that's valuable.
No, I think it's very important to have the facts discussed. It's very important. This bill prohibits the funding, and this is the difference. It's very important, and I never walked into an intelligence brief where we had an outside group that was telling us about the threat we were going to face that wasn't particularly vetted by the experts.
I just want to read, because you sort of keep making that distinction when we go down to SCIF, and that's a particular classified setting for this, right? And this is the ability of DHS to engage with external stakeholders in a variety of different conversations, and how you sort of have framed this bill about the predecessor and then any future, right, advisory group means that it's really going to tie the hands of this DHS, the next DHS, and any DHS moving forward. And to me, why would we do that, to the ranking member's point, when we seem to all be in agreement that it's really helpful to get these external parties? And if you think it's important, then you need to be able to appropriate money, and any money appropriated to DHS to be used in furtherance of an advisory group that seeks these opinions.
Will you yield for a second?
I yield.
Yeah, I'd like to work with you in future Congresses on our oversight.
Yeah.
And if you'd allow me to enter this into the record.
Only if it's good stuff.
It's good stuff. This is the HPSI bill that basically says that it's the same language.
Yeah.
Mr. Chairman?
Without objection.
I'd like to work with you because I think our job is oversight regardless of political party. That's what this bill is about, is let's hit the reset button. In our opinion, and you may disagree, I agree with Mr. Jimenez. This was a political maneuver. We want to hit the reset button to get back to intelligence. We're not okay with this. My constituents aren't okay with it. We want to hit the reset button so we have good, factual intelligence that keeps our country safe.
And I think the oversight function is exactly what you're trying to get at, right? And totally understand, and you can have your viewpoint, which may differ from Mr. Goldman's, from other colleagues, et cetera. That's entirely fine. But this bill goes so far beyond what you're trying to achieve, when we all seem to be in agreement that connecting the federal executive branches with outside voices is critically important. If we think it's important, then we need to be able to fund it. And so I understand you may be frustrated, I understand you may be upset with what happened, but to say and tie DHS's hands when they have such a critically important mission, why this committee is so important, and they will not have the ability, and if they use any money appropriated to them to anything that looks like that, we're gonna have a problem. And so I think we can better achieve what you're looking for, not by this bill, but by other pursuits. I yield.
Mr. Mendes,
It's trust.
Yeah.
We don't trust. My constituents don't trust. They're demanding a reset. They just don't trust. This bill hits the reset button to get the trust back, to restore trust.
And we can go back and forth. I know the lies and liars has been used a lot. It's not for me. But that's also what political elections are for, if people don't have trust, right? And we're supposed to legislate and uplift and the work that our professionals do at DHS, no matter what the administration is, right? And we have oversight of it, and we're supposed to exercise that oversight function, right? But if there's a lack of trust, I believe that belongs to the American voters to elect a new president. That being said, if we are gonna use lies and liars and accuse people across the aisle back and forth, be very careful. Be very careful, because Mr. Jimenez says history comes back to bite you. Do you think the former president has been truthful with the American people from the time that he ran in 2016 to date? Because if you don't, then be very careful of who you accuse to be a liar. And I would just leave it there. I yield to Dan Goldman.
I want to flag one thing on that, just to follow on what Mr. Menendez said, that I think is very important. And I think that this notion that, oh, my constituents tell me this, the constituents tell you things that you have fomented. And they react to the partisanship that they are hearing. And I think we all need to be very, very careful, whether we're talking about the First Amendment or otherwise, of determining that someone has political bias that they cannot leave at the door, and that they are incapable of ever being nonpartisan if they have given a donation to a political candidate. That is going to nullify a lot of expert people from any nonpartisan job, and I think we need to be very careful about that. And I yield back.
Gentleman yields back. The gentleman's time has expired. Do any other members wish to be recognized to speak on the amendment? The chair recognizes the member from the great state of Rhode Island.
Thank you, Chairman. Just 2 points. First, let's not mistake the fact that foreign actors, including Russia, have tried and are continuing to try to influence our elections. It's not a conspiracy, it's not a hoax, it is real. It is the opinion of the intelligence community, the Department of Justice, In fact, just recently, the Department of Justice has put out arrest warrants against both U.S. and Russian individuals for attempting to influence our elections. And we do a grave disservice to the people we represent if we try to deny it or downplay it just because we think that those foreign actors might help our preferred candidate. But separate and apart from all of that, I want to again reinforce what Ranking Member Thompson said, which is that even if you disagree or even if you're okay with foreign actors trying to influence American elections or sow division or turn Americans against each other, the language of this bill is very broad. It would ban funding for any Homeland Intelligence experts group and doesn't even really define what a Homeland Intelligence experts group is. So is it to be read as you can't convene a group of industry experts to advise the Department of Homeland Security on any intelligence matter? We talk a lot in this committee about the importance of getting ahead of artificial intelligence, about the importance of getting ahead of quantum computing and other methods of modernizing DHS. Certainly, we will need advice from the private sector on how to do that. Certainly, we should be working collaboratively with the private sector to make the homeland more secure. And to suggest that we shouldn't do it because some of the individuals in an advisory group might have political opinions that match those of their administration, well, geez. I mean, I would guess that most people on advisory committees in a Republican administration are Republicans. Hopefully not all. Hopefully you want a diversity of opinions, but I would guess that most of them would be Republicans. And in a Democratic administration, I would guess that many of them would be Democrats. That's why we have elections. So listen, there's a lot to unpack here, but at the very least, as Ranking Member Thompson has suggested and others have echoed, the language in this bill as it is written appears to be so broad and the definitions are so vague that it could be read as to ban all kinds of interactions with experts that may help make our homeland more secure. So without belaboring it, I would encourage my friend, the sponsor, and others to maybe go back to the drawing board, refine this, be more specific about it, because the language is very broad as I read it, and I'll yield back.
Gentleman yields back. Do any other members wish to be recognized to speak on the bill? Seeing none, are there any amendments to the amendments in the nature of a substitute? Hearing none, the question is now on agreeing to the amendment in the nature of a substitute offered by Mr. Pfluger. All those in favor, please signify by saying aye. All those opposed, please signify by saying no. In the opinion of the chairs, the ayes have it, and the amendment in the nature of a substitute is agreed to. The question now occurs on reporting the bill, H.R. 5729, as amended to the House with a favorable recommendation. All those in favor, please signify by saying aye. All opposed, please signify by saying no.
No.
In the opinion of the chairs, the ayes have it, and the motion is agreed to.
Mr. Chair,
The ranking member is recognized.
ask for a recorded vote.
A recorded vote is requested pursuant to Committee Rule 7C. Further proceedings on this question are postponed. Chair now moves to H.R. 9.
New York. Thank you, Mr. Chairman. Here we are again for another hearing about the same topic. And I want to say I appreciate the concerns about how the FBI addresses and investigates whistleblowers or retaliates against whistleblowers. And we've had a number of hearings on this in this committee. And Mr. Horowitz, I'm glad you are looking into it. That is your job, and that's what you should do. But let's be real. This is the weaponization of the federal government subcommittee. Whistleblower retaliation is peanuts compared to a future president using the power of his office to imprison his political adversaries simply because they oppose him. That is the ultimate weaponization of the federal government. And we don't have to question whether or not Donald Trump will do this in the future, because we know how this story plays out. We've seen it, and he's done it in the past. I want to introduce
an article from last Sunday's New York Times entitled, "As President, Trump demanded investigations of foes. He often got them. He has threatened to target his perceived enemies if elected again. A look at his time in the White House shows how readily he could do so." Let's just go through some of the things that Donald Trump did when he was president the first time. James Comey testified that Trump asked him for a pledge of loyalty and then requested that Comey drop the investigation of former National Security Advisor Michael Flynn. Comey refused. Trump fired him. Trump also fired Deputy FBI Director Andrew McCabe because he oversaw an investigation that Donald Trump didn't like, just days before McCabe would have earned his full retirement pension. Trump then demanded that the IRS investigate Comey and McCabe, among others. Well, that's not all. At Trump's direction, the Justice Department dropped its case against former National Security Advisor Flynn, who had pleaded guilty to lying to the FBI. Mr. Kirshner, in your 30 years of experience, are you aware of any other situation where the Department of Justice withdrew a case after someone, a defendant, had admitted to the conduct under oath in court?
I am not.
Let's move on. Donald Trump pressured overtly the DOJ to reverse its sentencing recommendation for Roger Stone. After Stone threatened to cooperate against Donald Trump, Trump granted him clemency. John Durham wasted millions of dollars on a baseless and fruitless investigation into the origins of the Russia investigation because Donald Trump demanded it. And it got so bad that Mr. Durham's number 2 resigned in protest to Durham's plan, pressured by Bill Barr and Donald Trump, to publish an interim report on the investigation shortly before the 2020 election in gross violation of DOJ policies. That's not all. Trump tried to install Jeffrey Clark as Attorney General because he acknowledged to the president that he would do his bidding and fraudulently try to help him overturn the election. But this is the one that really gets to the nub of this. And Mr. Levitt, we're talking about First Amendment, infringement on First Amendment rights that you are alleging has happened to these FBI agents. You would agree, would you not, that writing a book is protected speech under the First Amendment?
Sure.
So let me just give you a hypothetical scenario. Somebody pleads guilty to a crime. He's sentenced and designated to serve his sentence at home. He is asked by the Department of Justice to sign an agreement saying that he would not write a book. He refuses to do that. As a result of his refusal, the Department of Justice throws him back into jail in solitary confinement. Is that, in your mind, the weaponization of the Department of Justice to infringe upon First Amendment rights?
I'm not a First Amendment lawyer, Mr. Goldman.
Well, you said this is all about a First Amendment infringement.
Well,
why are you testifying about that if you're not an expert? The answer, because my time is running out, excuse me, the answer, because my time is running out, is that actually happened by Donald Trump to Michael Cohen. A judge intervened immediately, reversed the decision because it's a gross violation of the First Amendment. It is a gross abuse of power of the Department of Justice, and Mr. Cohen was let out. But this is who now has complete immunity to do this as much as he wants without the guardrails of Don McGahn or John Kelly to stop him from doing it. This is going to be the danger of the weaponization of the federal government. I yield back.